Good afternoon, everyone. Welcome back to the Junior Scholar Symposium on Public International Law. This is our 5th edition of the symposium. We've done this starting December 2020, and we've done it every semester, and now we're on our 3rd year. On our 3rd year, we have almost 350 case studies already. For this symposium, we'll be listening to the presentation of 85 LEAP Fellows, LL.M students, and J.D students. This is now our 3rd session of the symposium. Earlier today, we heard the presentation from 25 students and LEAP Fellows. I now invite the beadle of BGC class day 2, is that right? For his presentation. So, Emmanuel Bonco.
So, good afternoon, everyone. So, my topic will be about an international law solution for the provision of the Philippine Immigration Act that excludes the entry of aliens who are characterized as idiots or insane persons and persons who have been insane into the Philippines. So, the rule is problematic because it gives rise to discrimination against foreign nationals with disabilities, specifically those who are experiencing mental illnesses or those incapable of regularly using their mental faculties, as well as it gives stigma against them. So to give an illustration of this situation, let's say Diego, a Mexican national with a particular mental illness that causes him to have violent episodes or the like, wants to enter the Philippines for the purpose of medical tourism or because he has family who is willing to take care of him here. So Section 29A of the PIA provides that the following classes of aliens shall be excluded from entry into the Philippines: idiots or insane persons and persons who have been insane. So on the basis of his illness alone and its characterization, he may be barred from entering the Philippines. So Article 18 of the UNCRPD will be used to authorize the entry of this particular class of aliens. So it provides that state parties shall recognize the rights of persons with disabilities to liberty of movement, to freedom to choose their residence, and to a nationality on an equal basis with others, including by ensuring that persons with disabilities are not deprived on the basis of disability of their ability to obtain, possess, and utilize documentation, as well as to be able to utilize relevant processes such as immigration proceedings that may be needed to facilitate the exercise of their right to liberty of movement. So though Article 18 of the CRPD does not specifically compel states to allow the entry of mentally ill aliens, Article 4 of the same directs state parties to ensure and promote the full realization of all human rights and fundamental freedoms. So this is without discrimination on the basis of disability, such that state parties are directed to take all appropriate measures, including legislation. So in relation to Article 18, one of the rights that state parties should promote, protect, and recognize is the right of persons with disabilities to liberty of movement. So the CRPD was created through one of the 3 processes accepted by the international community of states or by means of treaty making, and the material source, therefore, is the text of the CRPD itself. So it's binding on the Philippine state because it was ratified on April 15, 2008, which entered into force on May 3, 2008. And it was domesticated following the transformation clause under the Constitution. So the effect of the CRPD on the PIA is that there is conflict. So we look into the applicability of 3 general legal maxims on overcoming the conflict. Lex superior is inapplicable since the domesticated pill rule is on the 3rd year, whereas the PIA is on the 2nd year. Lex specialis is applicable since both pertain to situations involving the immigration proceedings of persons with disabilities. However, the PIA does not qualify who is considered as an idiot or an insane person, whereas the domesticated pill rule defines what a person with disability is. So lex posterior is likewise applicable to resolve the conflict since the PIA was enacted in 1940, whereas the CRPD came into effect in the Philippines in 2008. So the convention provides a legal basis to authorize the entry of such class of aliens. And going back to my hypothesis, Diego may finally enter the Philippines without being barred from doing so. So in conclusion, if there's one thing I learned from the past 3 years, it's that you aren't either mentally healthy or mentally ill. Mental health is a wide spectrum, and where we fall on that spectrum varies from a case-to-case basis, day-to-day, or even R-to-R. So you might have noticed that during the increased travel restrictions, your mental health slipped a bit more during stressful times, even if you didn't qualify for a diagnosis of depression, anxiety, or some other mental illness. Your mental health might not have been as good as it could be. So taking this into consideration, it would be unjust to have the PIA, which discriminates against people with mental illnesses. Moreover, gives stigma to those people without providing a clear basis for the rule and a clear definition as to what would qualify under the classification under the PIA, despite the Philippines' commitment to implement the CRPD. Thank you. So I would like to call on Mr. Capuno to present next.
Thank you. Good day, everyone. My topic addresses the forcible usage of English and ban on speaking Filipino in public elementary schools. This is typically used as a measure to increase English proficiency of child students. Yet, the rule not only forcibly alienates a youth from his mother tongue by depriving him the right of its use, but also implicitly and institutionally asserts the superiority of English over a supposedly inferior Filipino language. The state, via the 1987 Policy on Bilingual Education, currently uses the two languages of Filipino and English as the official media of instruction and allocates to them their own subjects for exclusive use therein. This takes the form of Araling Panlipunan and Filipino, being taught in Filipino, and math, science, and English, being taught exclusively in English. However, Philippine rules of domestic origin are silent when it comes to the suppression of use of one's own mother tongue in schools, on campus, outside of classes. There's thus a gap in Philippine rules from domestic sources on the matter. In practice, however, schools through their principals may have faculty scold or punish students for speaking in Filipino, even during breaks, like recess or lunch, or before or after class hours while still on campus, even if not speaking with their teachers on academic subject matter, or even if just in casual conversation with other students. The specific terms may vary from school to school, but it is commonly known as the English-only rule. A hypothetical example of this would be a public elementary school student's handbook, as written by the principal and published by the school, stating, "A jug or repeating line writing punishment shall be imposed on a student conversing in Filipino or in a language other than English while on campus outside of Filipino and Araling Panlipunan classes, spanning 20 lines on the first infraction, with an additional 5 lines added for each subsequent infraction of this rule." Thus, I propose drawing upon the 1990 Convention on the Rights of the Child, serving as material source for our purposes with the formal source as international agreement, which was ratified as a treaty to which the Senate had concurred in via Senate Resolution number 109, series of 1990, and to which the Philippine state is bound under international law as a state party thereto, and contains a relevant provision which we had since domesticated via doctrine of transformation into a Philippine rule on the same level as a statute. This article is Article 2, number 1, which mandates that state parties do not discriminate against a child's language. Specifically, it states that state parties shall respect and ensure the rights set forth in the present convention to each child within their jurisdiction without discrimination of any kind, irrespective of the child's or his or her parents' or legal guardian's race, color, sex, language, religion, political or other opinion, national, ethnic, or social origin, property, disability, birth, or other status. The forced usage of English and banning of Filipino outside of applicable classes hours would be a form of discrimination against children in line with that article. The law thus fills in a gap in Philippine rules from domestic sources. This brings us to my topic, Convention on the Rights of the Child as basis to authorize public elementary school students to use their native language while in school. Thank you everyone for your time. And next, I would like to call upon Mr. Policarpio to present his topic.
Okay, good afternoon to all. My name is Miguel Policarpio, and today I will be presenting on the Philippine problem which I have identified, which is the removal of subversive materials from the libraries of state universities and colleges, or SUCs. Ultimately, I will be discussing how this issue may be remedied by use of the provisions of the International Covenant on Civil and Political Rights, or the ICCPR. So first, imagine a setting where libraries are constantly under censorship and where books are constantly being confiscated at random. Imagine a setting where a university student is not free to access certain materials or works of literature simply because these materials have been branded as subversive and in support of terrorist ideologies. As we witnessed last year, this could very much become a norm for state universities. Last year, J.D. Regional Memorandum number 113 was passed, and under this directive, several books were confiscated and removed from the libraries of SUCs. What is alarming is that there are no specific guidelines or list of books given. Anything that was deemed or found to be subversive and in support of communist terrorist ideologies were confiscated. So this J.D. directive sets a vague and dangerous legal precedent and puts the future of our libraries at risk. So to further protect our state university libraries, we can turn to the ICCPR as basis to declare void this J.D. directive and to prevent the future removal of books from our state university libraries. So the international rule I am invoking in this case is Article 19.2 of the ICCPR, which extends the definition of freedom of expression to include the freedom to seek, receive, and impart information and ideas of all kinds, regardless of frontiers. I state that libraries, as an academic frontier and as valuable repositories of information, fall within the ambit of this provision. They too deserve protection from censorship and confiscation. So the formal rule of this international rule is the treaty itself, which is the ICCPR. This is a multilateral treaty which enjoins contracting nations to respect civil and political rights. And the material source of this rule is the text of the provision itself, which is Article 19.2. Now, the ICCPR is binding upon the Philippines as we have complied with the formal requirements to become a party to this treaty. Our country signed this treaty in 1966 and ratified its membership in 1986 through President Corazon Aquino, who was exercising lawmaking powers at the time. This treaty has since been domesticated through the process of transformation and now enjoys the same power as a statutory rule. In this case, this statute has the effect of being used as a reinterpretation of existing Philippine legal rules. At this moment, there are no laws or jurisprudence specifically protecting libraries from confiscation. The existing Philippine rule that may be invoked is Section 4, Article 3 of the 1987 Constitution, which provides that no law shall be passed abridging the freedom of expression. Article 19.2 of the ICCPR can be applied in this case to extend this freedom of expression to that of the freedom to impart information through all frontiers. This should apply to the frontier of SUC libraries as well, where their librarians should be free to impart information of all kinds in pursuit of academic freedom. Thus, with the aid of the ICCPR, as a reinterpretation of existing Philippine legal rules, the relief I seek is to declare void this J.D. directive, as this directive infringes upon the freedom of expression of libraries to impart information of all kinds to the students who will benefit from its use. Hence, we must declare this directive void for violating the freedom of expression granted not just by our own laws, but also by treaties such as the ICCPR. This would prevent a dangerous precedent from taking hold, where our libraries would constantly be at risk of confiscation and of censorship. Thank you very much for listening. I now yield the floor to the next speaker, Ms. Reneses. Thank you.
So good afternoon, everyone. So for my case study, the Philippine problem that I identified is that athletes with disabilities receive smaller cash incentives. So to illustrate this, take a look at Republic Act number 10699, or the National Athletes and Coaches Benefits and Incentives Act. Under Section 8 thereof, able-bodied athletes who medaled in international sports competitions get twice as much cash benefits as athletes with disabilities. So for instance, gold medalists in the Summer and Winter Olympic Games, they get 10 million pesos, while gold medalists in the Paralympic Games only get half of that, which is 5 million pesos. Champions in the Asian Games are entitled to 2 million pesos, while those in the Asian Para Games receive 1 million pesos. And gold medalists in the SEA Games obtain 300,000 pesos, while similar medalists in the ASEAN Para Games receive 150,000 pesos. This disparity sends the message that medals won by Filipino para-athletes have less worth. To address this problem, the relief I am seeking to obtain is to compel the Philippine Sports Commission to provide athletes with disabilities the same cash incentives as athletes without disabilities. The Convention on the Rights of Persons with Disabilities is a rule of international law that can provide this relief. Under Article 35 of the Convention, this states that with a view to enabling persons with disabilities to participate on an equal basis with others in sporting activities, states parties shall take appropriate measures to encourage and promote the participation to the fullest extent possible of persons with disabilities in mainstream sporting activities at all levels, and to ensure that persons with disabilities have an opportunity to organize, develop, and participate in disability-specific sporting activities, and to this end, encourage the provision on an equal basis with others of appropriate instruction, training, and resources. Under international law, the Philippines is bound to the CRPD as it is a party to the said international agreement. The President ratified the CRPD on April 15, 2008. It then entered into force in May of 2008. The CRPD was domesticated into Philippine law through the doctrine of transformation for executive agreements, as the convention was ratified by the President, but it was not concurred in by the Senate. Since the CRPD is a mere executive agreement, its place in the hierarchy of Philippine legal rules is in Tier 3 or on the same level as executive regulations. I submit that this domesticated rule of international law may be used to reinterpret Republic Act number 10699 in order to compel PSC to provide athletes with disabilities the same cash incentives as athletes without disabilities. So that concludes my presentation. Thank you for listening. I'd like to introduce the next speaker, Ms. Kija at Sharon.
Good afternoon, everyone. My name is Kija Chiron. This afternoon, the Philippine problem that the case study seeks to address is the school's restriction of students' free speech. As of late, there have been several instances where school administrations have had to intervene in student affairs in an attempt to censor, restrict, and regulate students' free speech. In 2018, for example, the second issue of the official senior high school publication of San Beda University, Manila, was pulled out for being too critical and too negative for the community of San Beda. This piece featured a caricature of Duterte sitting on an iron throne with dead bodies piled up on his feet. In 2020, meanwhile, youth groups criticized the University of Santo Tomas Senior High School Department for issuing a guideline requiring student organizations to seek the school's permission before posting anything online. 3 senior high school students from UST have also been dismissed from the institution because of political posts that pertained to the government's response to recent typhoons. Considering the political climate of our country today, where democratic institutions continue to be under attack, it is thus imperative to take measures to ensure that the students' democratic spaces and freedom of speech are protected. This case study particularly focuses on the penalty of non-readmission imposed by UST on a senior high school student. This was imposed on the student after the said student posted a status which indicated his disdain for the incompetence of the Philippine government in responding to the recent Philippine typhoons. The same student also called for the implementation of academic ease due to the destruction brought by the typhoons. According to Section 9, Number 7 of BP 232, or the Education Act of 1982, students and pupils in all schools shall enjoy the right to free expression of opinions and suggestions and to effective channels of communications with appropriate academic and administrative bodies of the school or institution. However, while this provision provides for the right of the student's freedom of expression, there is a gap as to the limits of the school's discretion in regulating said free speech when such a need arises. Article 13, Number 2 of the Convention on the Rights of the Child fills this gap. The said provision provides that the exercise of the right of freedom of expression may be subject to certain restrictions, but these shall only be such as are provided by law and are necessary. Number 1, for the respect of rights or reputations of others, and number 2, for the protection of national security, public order, public health, or morals. Thus, when applying the international rule, where students are not infringing upon the rights and reputations of others, or threatening national security, public order, public health, or morals, their right to freedom of expression must be protected. The Convention on the Rights of the Child defines a child as a human below the age of 18 years. Thus, the Convention applies to senior high school students in the Philippines whose ages range typically from 16 to 18 years old. The Convention on the Rights of the Child is binding to the Philippines as it was signed on January 26, 1990, was ratified by the President on August 21, 1990, and was officially domesticated into Philippine law through transformation when it was concurred in by the Senate on July 26, 1990. Thus, this is on the same level as a statute in the Philippine legal system. The legal relief sought here is to prohibit UST from taking disciplinary action against a senior high school student for posting political comments online. It is argued that while Section 9 of BP 232 provides for the right in question, it is not enough to provide this relief as it leaves a gap with regard to the permissible restrictions when a school's regulation of speech is needed. Article 13, Number 2 of the CRC is supplementary to the Philippine Rule, Section 9, BP 232. It fills a gap in the law as to the limitations and parameters on the school's restriction and regulation of students' free speech. The focus here is to prescribe the restrictions that should be imposed on educational institutions on its discretion to regulate. This therefore establishes when schools may restrict speech. applied, the UST student's post does not fall under the permissible restrictions embedded in the CRC. UST should then be prohibited to take disciplinary actions against the said student. This is to say that the Philippine rule must be taken in conjunction with the international rule in order to give sufficient basis for the relief sought. Thank you for your time. May I call on Mr. Ian Paolo Catalan for the next presentation.
Sige, let me call the first 5 presenters to come here in front, and then you'll answer questions. So we'll stop every 5 presenters so I can ask you your questions. Sige, so okay, so for Eman, can you flash your slide? Okay. No, that's next one. CRPD, right? CRPD. I think in your presentation you said that there's a, use the mic, there's a conflict between the Immigration Act and the international agreement. Can you please clarify 2 things? Number 1, on which tier is the domesticated international rule in the Philippine hierarchy? Is it 2nd tier or 3rd tier?
In the Philippine hierarchy, sir, the CRPD is on the 3rd tier as an executive agreement.
Okay, executive agreement.
Yes,
Okay.
sir.
And did you say that there's a conflict, right? There's a
Yes, sir,
conflict
there
between
is a
the Immigration Act and the domesticated CRPD, which is on the 3rd tier.
Yes, sir.
Now, which principle of statutory interpretation shall we apply to resolve the conflict between the statute and the executive agreement?
Yes, sir. So there are actually 2 principles applicable in this case, sir. So the first one is lex specialis, which is applicable since both pertain to situations involving the immigration proceedings of persons with disabilities. However, the PIA does not qualify who is considered an idiot or an insane person, whereas the domesticated pill rule, the CRPD, defines what a person with disability is. And the lex posterior is likewise applicable to resolve the conflict since the PIA was enacted in 1940 while the CRPD came into effect in 2008. So the inconsistencies between the CRPD and the PIA, the CRPD will govern, sir.
Okay, so in the 7-step analysis, we're supposed to apply the sequential analysis.
Yes, sir.
So the first of the StatCon principles would be lex superior.
Yes, sir.
So if we apply lex superior, which rule will prevail?
The rule that will prevail will be the CRPD, sir. The PIA, since it's on the 2nd tier, whereas the CRPD would be on the 3rd tier.
Right. So as we said, we apply the StatCon principles in the correct sequence.
Yes,
so
sir.
First, we apply lex superior, and if we apply lex superior, we can resolve the conflict, right?
Yes, sir.
The Immigration Act will prevail.
Yes, sir.
Okay. So your pill rule won't, you can't use the pill rule, right, in your case, because the Immigration Act will prevail.
Yes, sir.
Tama? Okay, sige. Tama ba?
Sir, however, the other 2 principles could still work if the first pill rule is inapplicable, sir.
If it's inapplicable.
Yes, sir.
So we apply it in the right sequence.
Yes, sir.
And so can we apply
Yes, sir.
lex superior?
We can apply, sir, lex specialis. And
No, can we apply lex superior? Because
no,
we
sir,
apply the 2 others.
lex superior is inapplicable,
Okay,
sir.
why is it inapplicable?
Sir, because the domesticated pill rule would be below a tier below the statute, sir.
Oh, okay. So therefore, if we apply lex superior, the Immigration Act would prevail.
Yes, sir.
And so if Immigration Act would prevail, then we can't invoke our CRPD.
Yes, sir.
Okay. So yeah, we can't get the relief that we want because we can't invoke it.
Yes, sir.
Okay. So yeah, so lex superior
Yes, sir.
should be the applicable StatCon principle. Okay, next. Paki-move ng slide, please. Okay, so Ren.
Yes, sir.
So the principle, okay, the pill rule that you want, CRC, you're invoking CRC, right?
Yes, sir.
If you
Article
read
2.
the provision, it does not expressly authorize public elementary students to use their native language. There's no mention of that. So how can we now interpret this broadly worded CRC to support the relief that you're seeking?
Yes, sir. So Article 2 should actually be read in relation, taken together with Article 29 of the same, which directs state parties to, in the education of the children, to incorporate in their development their cultural identity and their language. But we also draw upon, mainly upon this one because it imposes a restriction on state parties from discriminating against the same. So what happens is that 29 necessitates the incorporation and incorporation of the language of the student, while Article 2 prevents it from being discriminated against, which is what occurs when they're prevented from being able to speak freely in their own language, and thus also contradicts Article 29.
Okay. So as important as 2.1 would be CRC 29, right?
Yes, sir.
Okay, so we don't have the text here.
Yes, sir.
Okay, thank you. For who's next? Okay, so Miguel. How ba? So for Miguel, you're invoking the ICCPR and you're saying the ICCPR has the effect of reinterpreting or clarifying the consti provision.
Yes, sir.
So if it's the consti provision as clarified or reinterpreted by ICCPR that you will apply, shouldn't we say that the J.D. directive is unconstitutional instead of merely void?
Sir, to declare said directive void would also have the same effect as being unconstitutional, sir, since it could be proven through the use of this international law provision that this directive would run counter to freedom of expression. Then going by the constitutional provision, sir, then it would already be deemed unconstitutional already, sir.
Okay.
So for it to be declared as void would have that similar effect, sir.
Right. So void is broader than being declared unconstitutional. I'm just thinking maybe unconstitutional is the more precise term.
Yes,
Because
sir.
really you're saying that the J.D. directive violates the constitutional provision as clarified or reinterpreted by ICCPR, right?
Yes, sir.
Yeah. Okay. Next. Janice. So for Janice, you're invoking CRPD. And if you look at Article 30, paragraph 5, it says here that states parties, including the Philippines, shall take appropriate measures. So that's the obligation, to take appropriate measures. It does not specifically say that states shall give the same cash prize to PWD athletes, right? So how can we interpret your Article 30.5 to support the relief that you want?
So, sir, Article 30, Paragraph 5 of the CRPD provides that states parties, like the Philippines, shall take appropriate measures to encourage the participation of PWDs in mainstream sporting activities at all levels. And it also provides that state parties must encourage the provision on an equal basis with others of appropriate resources, such as cash incentives. So, sir, for the intended purpose of the cash incentives under Section 8 of RA 10699, the purpose of this is to incentivize or motivate high-performing athletes in order for them to continue training further so that they could win more medals. And another purpose is to promote excellence in sports. And so with this, we can interpret CRPD in a way as to compel the Philippine Sports Commission to provide athletes with disabilities with the same cash incentives as athletes without disabilities.
Okay, so in interpreting Article 30.5 to support the relief that you seek, what rules of interpretation should we follow?
Sir, according to VCLT, we should provide we should give the words
with their ordinary meaning.
Okay, so which words would those be?
Sir, to encourage and promote participation of PWDs in mainstream sporting activities at all levels. So at all levels, this would include the highest levels in sports like international sports competitions, like the Olympics, the Paralympics.
Okay,
Shut
okay, thank you. Next, Keisha. So you're invoking the Convention on the Rights of the Child, saying that the child has freedom of expression, right?
Yes.
And there should be no restriction on making political comments online. I think you mentioned the constitutional provision, did you?
No,
No?
sir.
Okay, so we know that the Constitution guarantees freedom of expression, right? We know that.
Yes.
Instead, you cited BP 232, and here, the students are granted rights, including the right to freedom, to free expression of opinions. So we have the constitutional guarantee of freedom of expression. We have this statute, which guarantees freedom of expression. Can't we just rely on the consti and the statute and not use CRC?
CRC would still be needed, sir, since the Bill of Rights would apply as against the state, so it can't be used against UST, sir.
Okay, but how about BP 2232? Doesn't that guarantee the right to free expression?
The international law, sir, merely supplies the limitations, sir, and controls and limits the discretion of the school when the need to regulate speech arises, sir.
Okay. I'm just curious about BP 232. So that seems to be a statute which confers a right
Yes,
on
sir.
students. And
Yes,
so I was
sir.
thinking maybe we can just rely on the statute and say that the right is protected by the statute instead of invoking a domesticated international rule, which will require a 7-step analysis. Too long.
Sir, it would supply the limits, sir. So,
Oh, you mean the restriction, the grounds for restriction,
yeah, the
protection of
grounds for
national security,
restriction,
public
sir.
order.
Yes, sir.
Okay. Okay. Thank you. Thank
you, sir.
Sige. So we'll invite the next 5 presenters.
So, good afternoon, everyone. I am Ian Paulo Catalan, and my case study will be on accessibility of sports training facilities for athletes with disabilities. So, picture this. Johnny is a para-athlete or an athlete with disability who represents the Philippines in para-games events in swimming. However, despite the fact that he's a national athlete, he has no accessible facilities, and as such, he has had to rent pools in his hometown. Johnny's situation is sadly nothing new, since para-athletes have experienced the same situation since 2020. So they lack training in 2020 due to the field sports complex being converted into a quarantine facility. Although they eventually resumed training for ASEAN Para Games, the fact that field sports is their only known training facilities highlights the lack of accessible training facilities throughout the Philippines, despite the fact that we have many sports facilities throughout the Philippines. Furthermore, the Philippine rule here is the Philippine Sports Commission Charter, which states that the PSC has the function to establish, maintain fully equipped sports facilities and centers in strategic places in the country, and as far as practicable, such modern complexes adequate for major international competitions. So, however, this is not enough, as persons with disabilities aren't really included in the equipment. They didn't specify whether persons with disabilities should be included. So something must be done to make more sports facilities accessible to athletes with disabilities. And we do that by having recourse to international law in the form of of the Convention on the Rights of Persons with Disabilities, specifically Article 30, Paragraph 5. Paragraph 5C provides that states parties should take appropriate measures to ensure that persons with disabilities have access to sporting venues. However, this alone is not enough as to specifically provide for training facilities for national athletes. So, an aid must be made, and the Vienna Convention on the Law of Treaties provides such aids. One aid is the use of subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation. So, a few examples of subsequent practices include in Wallonia in Belgium and Bosnia and Herzegovina, where legislation is in place to ensure accessibility of sporting venues. In Moldova, Law Number 60 requires legal entities to facilitate access to sporting venues. In the Action Plan for Persons with Disabilities in Montenegro, sports facilities should be adapted to the needs of the persons with disabilities. And finally, in Poland, the municipal stadium of Wrocław is adapted for persons with disabilities. So, how is this effective in the Philippine setting? First of all, the CRPD is an international agreement in the form of an executive agreement. It's binding in the Philippines as we are a signatory, as having signed it in September 25, 2007, and deposited the instruments of ratification on April 15. However, there is no Senate concurrence to this treaty, bringing it to the level of an executive agreement. So, being an executive agreement, it has the same force as that of an executive regulation. So there is a so it's below the law in question, which is a statute. Fortunately, there is no conflict between the executive agreement and the statute in question. So it only fills a gap by including persons with disabilities in the equipment for the sports facilities of the PSC. So it's more specific in terms of providing access for persons with disability. So given these circumstances, the CRPD can be a basis to compel PSC to make facilities more accessible and provide training facilities for every athlete, whether able-bodied or disabled. Thank you po. Thank you. And may I call on the next speaker, Ms. Fernandez.
Good afternoon, everyone. So my topic is UN Convention on the Rights of Persons with Disabilities, or the CRPD for brevity, as basis to compel the issuance of lifetime PWD ID cards for persons with permanent disabilities. So the Philippine problem is the limited validity of PWD IDs. As you can glean from the slides, the administrative order issued by the NCDA provides for a validity of only 5 years. This poses a predicament because by limiting its validity, which by law is the basis for entitlement to the privileges granted under the Magna Carta, including discounts on goods and services, and VAT exemption for transportation, fare, medicine, and medical services, we are also putting a time bar to its access. The 5-year limit, however, is not without reason. It is a safeguard on the end of the agency so that it could reevaluate the health of the holder vis-a-vis his or her continued eligibility. Re-evaluation, however, is counterintuitive and superfluous if faced with a PWD who has sufficiently proved during the very first application that his or her disability is characterized by permanence. It adds an unnecessary burden and is in fact a waste of resources to still reapply and enter one's personal appearance before the renewing offices for countless reassessment throughout one's lifetime. To put this further into context, think of a person with Crohn's disease. It's a disability with no known cure, on top of facing financial constraints. If his or her hospital confinement coincides with the expiry date of the PWD ID, then he or she is effectively barred from availing the aforementioned benefits, which would have been of great help in lowering the hospital bills. This is the exact crisis that my brother, together with us, his family, has been bracing for years. It is for this reason, and the many unheard, or heard but not listened to struggles of PWDs, that I seek recourse from international law, specifically the CRPD, to compel the issuance of lifetime IDs for persons with permanent disabilities from the government agencies tasked with its issuance, the PDAO and the NCDA. The CRPD is binding as a law. It is an international agreement which creates law for the parties and is accepted as such by the international community of states. It's binding in the Philippines, as we have complied with the formalities prescribed by the agreement, specifically the steps in becoming a party to the convention. First, the signing. It was signed on September 25, 2007. And second, the ratification of the said treaty by former President Gloria Macapagal Arroyo on April 15, 2008. It has been domesticated into Philippine law by transformation, and following the doctrine in Sagisag versus Ochoa, CRPD as an executive agreement is regarded as being on the same level as that of an executive rule, local ordinance, or procedural rule. Moving forward to the specific rules of international law, Article 5 provides that in order to promote equality and eliminate discrimination, state parties shall take all appropriate steps to ensure that reasonable accommodation is provided. In interpreting the said provision, Article 31 of the Vienna Convention on the Law of Treaties provides that the treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty. And if you peruse the text of the CRPD, reasonable accommodation is clearly defined as necessary and appropriate modification and adjustments, not imposing undue burden. So by bringing to the fore that if necessary adjustments were to be made so that PWDs can enjoy or exercise human rights and fundamental freedoms, this should not be in the face of undue burden. The cited international rule thus addresses or fills a gap in Philippine rules for domestic sources. The NCDA or PDAO can be compelled to lift the 5-year ban in our jurisdiction and grant lifetime PWD IDs to persons with permanent disabilities, thus ensuring unimpeded access to appropriate and affordable services, which are tapped by the presentment of a valid PWD ID card. In closing, it need not be stressed enough that the PWDs are, if not, the most excluded group in society. And it is high time that access to the replete benefits and privileges granted by our laws be no longer crippled by bureaucratic processes that serve no other purpose but to further burden them. Let's not render illusory the century-long struggles of fighting for their interest. It is a matter of justice. Thank you. For the next speaker, may I call on Mr. Galinato?
Good afternoon, sir. Good afternoon, everyone. So today, my case study will be tackling the problem wherein private businesses are temporarily taken over by the government without compensation. So I seek to use customary international law as reflected in the RP Germany Bilateral Investment Treaty in order to compel the Department of Interior and local government to give compensation for the temporary takeover of a hotel during a national emergency. So take this case, for example. Wunderbar Hotels is an international hotel chain with its headquarters in Germany. It operates business hotels across the globe. One of its hotels is in Bonifacio Global City, NCR. Now, at the height of the COVID-19 pandemic, Congress passed a law authorizing the president to take over privately owned public utilities and businesses for the purpose of augmenting the government's quarantine and medical facilities, as well as provide for dormitories for frontliners. Congress invoked Article 12, Section 17 of the Constitution, which provides that in times of national emergency, when the public interest so requires, the state may, during the emergency and under reasonable terms prescribed by it, temporarily take over or direct the operation of any privately owned public utility or business affected with public interest. According to Congress, there is an urgent need to increase the country's quarantine and medical facilities amidst the high congestion rate in both private and public hospitals in the NCR and its nearby provinces. Having been authorized by Congress, the President, through the Department of Interior and Local Government, proceeded to take over the operations of Wunderbar's PGC Hotel. Wunderbar demanded compensation for the taking, but the DILG denied its claim. According to the DILG, the takeover is only temporary and it is an exercise of police power. The DILG cited the case of ASEAN versus Piatco, where the Supreme Court ruled that there is no compensation for the exercise of this taking because it is an exercise of police power. However, there's a problem in this case. The problem is that a private business may be taken over by the government without just compensation. It is undeniable that there is taking here, albeit it is temporary. The Supreme Court in ASEAN versus Piatco ruled that the taking exercised under Article 12, Section 17 of the Constitution is done under the state's police power. Thus, there is no requirement for payment of just compensation. So how do we solve this problem? Rules of international law can provide a solution to this problem. Customary international law, as reflected in the Philippines-Germany Bilateral Investment Treaty, provides that investments by investors of either contracting state shall not be expropriated, nationalized, or subjected to any other direct or indirect measure, the effects of which would be tantamount to expropriation or nationalization in the territory of other contracting state except for public benefit and against compensation. This provision reflects the rule of customary international law that whenever government takes private property, it must be accompanied with the payment of just compensation. According to the third restatement of U.S. Foreign Relations Law, customary international law results from a general and consistent practice of states, followed by them from a sense of legal obligation. And international agreements create law for the states parties thereto, and may lead to the creation of customary international law when such agreements are intended for adherence by states generally and are in fact widely accepted. Several other bilateral investment treaties contain a similar provision which requires compensation in cases of direct and indirect expropriation. Furthermore, the Universal Declaration of Human Rights and ASEAN Human Rights Declaration both declare the existence of the right to property. Since this is a rule of customary international law, this is binding upon the Philippines, and it has been domesticated through the process of incorporation under Article 2, Section 2 of the Constitution, which provides that the Philippines adopts the generally accepted principles of international law as part of the law of the land. Having been domesticated, this rule of customary international law is at the level of a statute under our domestic sphere. Its application here in the Philippine legal system will result in the reinterpretation of Article 12, Section 17, such that it now requires the payment of compensation. Therefore, we can use this rule of international law as basis to compel the DILG to give compensation for its temporary takeover of Wunderbar's hotel. Thank you. Now, please welcome Ms. Angelica Pinga for the next presentation.
Thank you, Mr. Galinato. Good afternoon, everyone. I am Angelica Pinga, and the Philippine problem which I intend to provide the solution using international law is the inadequate and lack of and poor They protested the lack and poor quality of food being provided to them. The Philippine rule relevant to our discussion is Republic Act 6975, or the Department of the Interior and Local Government Act of 1990. Chapter 5 of the DILG Act provides for the organization and the powers and functions of the BJMP. Notably, Section 63 thereof states that great care must be exercised so that the human rights of these prisoners are respected and protected, and their spiritual and physical well-being are properly and promptly attended to. Given the broadness of this statement, there is a gap, as the Philippine rule stated does not provide for the certain legal right of the PDLs to be provided with adequate and nutritious food. This gap is filled by the domesticated customary international law as reflected in Rule 22.1 of the United Nations Standard Minimum Rules for the Treatment of Prisoners, or the Nelson Mandela Rules. It is stated under the said rule that every prisoner shall be provided by the prison management at the usual hours with food of nutritional value, adequate for health and strength, of wholesome quality, and well prepared and served. This customary international law, as reflected in the Mandela Rules, is binding upon the Philippines under the international legal system because first, the Mandela Rules have been universally acknowledged minimum standards for the detention of prisoners, and they have been of significant value and influence in the development of correctional laws since their adoption in 1955 by the first UN Congress on the Prevention of Crime and the Treatment of Offenders. Second, there are two in the Philippine statute, that is Republic Act number 10575 or the Bureau of Corrections Act of 2013. More so, the rule is domesticated through incorporation. Pursuant to Articles 2, Section 2 of the Constitution, which provides that the Philippines adopts the generally accepted principles of international law as part of the law of the land, and as such, it has the same status as a statute under the second tier in the Philippine hierarchy of rules. In conclusion, the domesticated rule as reflected in Rule 22.1 of the Mandela Rules fills the gap in the Philippine rules and can now be applied as basis to compel BJMP to provide adequate and nutritious food to PDLs. That will be the end of my presentation. Thank you for your time and attention. I will now give the floor to Ms. Aldrin Sinoes.
Good afternoon, everyone. So the problem presented before us and problem I seek to be relieved from through APAL rule would be that homework takes up most of a student's weekend, specifically an elementary student. So in here, we should note that homework has always been part of the academic cycle of a child. Children's lives, however, need not to revolve around this, for a well-rounded development focuses not only on the academic aspect, but other activities as well, including even leisure and rest. Research from the UN and UNICEF has highlighted that leisure should be understood as an opportunity for growth, recreation, and participation in society, not just a time when productive activities or personal obligations are halted. It is precisely during this developmental time that children carry out activities that help them define their identities and autonomous lives. A problem presented, however, is that homework takes up most of a student's weekend, rendering them unable to do activities leisurely at best, or they are not able to rest at all. Case in point is Junjun, a grade 5 student from a private Catholic school. So such a 10-year-old boy has been having a hard time to rest during weekends, the day where school works were supposed to be at a ceasefire. He could have used said days to rest, spend time with their loved ones, relax, and even take on activities he can leisurely do. This dream of free time, however, for these children has long been neglected due to the non-prohibition of giving of homeworks during the weekend. This paper then aims to discuss how the Convention on the Rights of the Child can be used as a legal basis to prohibit the teachers from giving homework to all public or private elementary students during weekends to give due respect to their right to spend time with people they hold dear, or to spend time leisurely, maybe through relaxation or rest from week-long academic days. It can also be noted that this provision under the convention can also cover students from high school, but for purposes of discussion, I will only be covering elementary students. So in the Philippines, In relation to the rights of the child to the free use of their time during weekends, we have Child and Youth Welfare Code. So Article 3 of such provides that every child has the right to full opportunities for safe and wholesome recreation activities, individual as well as social, for the wholesome use of his leisure hours. TEPED Memo 392 series of 2010 basically provides that no homework shall be given during weekends for pupils to enjoy their childhood and spend quality time with their parents without being burdened by the thought of doing lots of homework, but only to public elementary school pupils. So applying it to our scenario, Junjun has been having this problem because there is a clear gap in the Philippine law. The DepEd memo specifically provides for a guideline only to the pupils of public elementary schools. Junjun, however, is not from a public school. This gap clearly impedes his right to leisure time, as clearly discussed both in PD 603 and the CRC. The Convention on the Right of the Child then can now be a basis to prohibit the private elementary school teachers from giving homeworks to students during weekends. It specifically provides that states parties recognize the right of the child to rest and leisure, to engage in play and recreational activities appropriate to the age of the child, and to participate freely in cultural life and the arts. Its formal source is a treaty-making process. Its material source is the text of the convention itself. So the CRC is binding upon the Philippines because it complied with the formalities prescribed by the agreement. And the Philippines signed the convention on January 26, 1990. It was ratified through the signature of the president then on August 21 the same year. And it was domesticated following the transformation clause under the Constitution, following the concurrence by the Senate. It also occupies the tier 2 in the hierarchy of rules in the Philippine legal system, which makes it on the same level as Philippine statutes. So the CRC will fill in the gap in the Philippine legal rules, particularly in PD 603 and furthering DepEd Memo 392, because in the absence of law or administrative agency issuance covering even private schools, respecting the right of the child to leisure time, the Philippines is legally obliged under the international law to respect such. In conclusion, we know that childhood is a very important milestone in a person's life, but by not addressing this gap in the children's right to leisure time during weekends, we are taking away their privilege of having their leisure time at their own disposal. In the absence of this domesticated PL rule, different problems on mental health, among others, may arise, not only affecting a person's childhood, but also their adolescence and even their adulthood. This ends my presentation, and thank you very much for listening. To discuss and talk about women deprived of liberty and their right to be... Thanks, sir.
Let's call the presenters. Okay, so after you present, please stay here so that when I call you for questions, you'll be there in front already, okay? So for Paolo, is he here? Are you here? Okay, Paolo, you cited the PSC Act, right? So that's a statute.
Yes, sir.
And it mandates the PSC to establish fully equipped sports facilities, correct? So there's no mention of PSC being obligated to make such facilities accessible to PWD athletes, right? Just, you know, make them fully equipped. Now, maybe one way of interpreting this absence of such an obligation is that maybe Congress intended PSC to establish facilities for non-PWDs in general and maybe special facilities for PWDs, meaning not all sports facilities will be accessible to PWDs, only those specially designed for them. Okay? So if that was the intention of Congress in the statute, that sports facilities be accessible to non-PWDs, would we not be creating a conflict with the statute if we interpret CRPD to require PSC to make all sports facilities accessible to non-PWDs, to PWDs also?
If it were interpreted that way, I think there would be a possible conflict. However, However, I don't think there's a conflict in this case in the CRPD between the CRPD provisions and the PSC charter and the provision in the PSC charter, since although yes, there is no mention of equipment for persons with disabilities, the fully equipped also can also be interpreted as there's no distinction between able-bodied athletes and persons with disabilities. So, if the conflict is only possible only if Congress intended for the law to have a provision specifically for only able-bodied athletes. But since there is no provision in this case for that only able-bodied athletes should access the sports facilities, there is no conflict between this and the CRPD, sir.
Okay. No conflict because
There's no conflict because the provision doesn't really distinguish between able-bodied athletes and persons with disabilities, sir. So it should be since there is no distinction, access should be assumed to be for all athletes, whether able-bodied or persons with disability.
okay, thank you. For Gia, tama?
Yes, sir.
Okay, sige. CRPD, Magna Carta of Disabled Persons. Do we really need to use CRPD to obtain the relief that you seek? Can't we just use the Magna Carta of PWDs or even the Ease of Doing Business Act, which tries to do away with red tape?
Thank you for the question, sir. So, first, sir, for the Philippine law cited, the Magna Carta, it could not be used as a relief because it's clear from the cited rule that it conditions the access thereto on the procurement of an ID. And also, in the said Magna Carta, it was actually the law that authorized the NCDA to provide for the limitation. With regard to the second law mentioned, sir, the Ease of Doing Business Act, when I check on the ARTA, which is the Anti-Red Tape Authority, basically that was formed pursuant to the Red Tape Act, and it is tasked with reviewing existing policies so that it be able to draft new rules and basically review existing policies that are still subjected to red tape. They are yet to draft new rules, and because of this, we don't really know until when PWDs would be subjected to the same 5-year limitation, and basically the privileges granted and tapped by this PWD IDs would still be impeded, sir.
Okay, thank you. So next, Coco. Okay, so you're saying that there's this unwritten but binding customary rule that if private property is temporarily taken over, payment should still be made, right? There should be payment of compensation, even though the taking over is merely temporary. Now, it would be good if indeed there is such a rule of international law requiring payment for temporary takeover. But how do we know that such a rule exists? Is the bilateral investment treaty between Philippines and Germany sufficient proof of the existence of that rule?
Okay, sir. Thank you for the question. So to answer the first question, the rule exists because there are numerous bilateral investment treaties which the Philippines has entered into, which contain similar provision of the same effect. So examples are the RP Mongolia Bilateral Investment Treaty, RP Austria, RP Argentina, RP India, RP Turkey, RP Switzerland, RP Canada. But it's not just the Philippines that has entered into a bilateral investment treaty with a similar provision. Other states have also entered into bilateral investment treaties with other states containing the similar provision. So for example, Hungary, UAE, Oman, Hungary, BIT, UK, Australia, Belarus, Hungary, Argentina, Japan, Canada, Hong Kong, Indonesia, Singapore, Israel, Myanmar. So it spans various regions across the globe. So from this, we can see that it exists as a customary international law. To answer the first question, yes, it does exist. The statement in the bilateral investment treaty are reflections of this customary international law. Now, to answer the second question, is the Philippine-Germany bilateral investment treaty enough to prove the existence of the customary international law? It's not enough because it's just one. So one executive agreement or one international agreement cannot prove the existence of a bilateral investment treaty. So that is why we have to take it into context with other bilateral investment treaties and other declarations in order to support the claim that such customary international law exists. And other BITs of other states support this claim. And even the Universal Declaration on Human Rights declared the existence of the right to property. And just recently, in I think 2017, the Philippines entered into the ASEAN Human Rights Declaration, which also declared the existence of the right to property. And there's also the American Convention on Human Rights, which also declared the existence of property and explicitly stated the payment of just compensation in cases of taking. So the Philippines-Germany bilateral investment treaty is not enough. It has to be taken into context, and it has to be proven along with other agreements, declarations as proof of the existence of the customary international law. And that is why I only stated that it's merely a reflection.
Why? How is customary international law created?
So customary international law is created by customary international law results from a general and consistent practice of states, followed by them from a sense of legal obligation. So the declarations and the bilateral investment treaties show that there is a general and a consistent practice, not just from one state, but many other states. And they follow this from a sense of legal obligation because they have bound themselves through the agreements and also enforce it within their jurisdictions.
Okay, thank you.
Thank you, sir.
For Angel, very similar questions. So you're invoking the Mandela rules.
Yes,
and
sir.
you rightly pointed out that the Mandela rules are soft law, right? They're not binding. And
Yes.
so you're just using them as a reflection of the binding but unwritten customary rules. So how are customary rules created? Very similar to my question to Coco. Number two, how do we prove the existence and content of these rules because they're unwritten, right? And number three, do the Mandela rules qualify as proof of such rules?
Sir, for the first question, under restatement as provided by stated by Mr. Galinato, the customary international law results from the general and consistent practice of states performed with them from a sense of a legal obligation. So, for the second question, on how we prove the existence and content of such rules, we prove them by first proving that states consistently practice the customary rules, and this is proved by this is proved if a state is considered to be customary international law is binding upon a state if the state does not state any objections to the customary rules, sir. So, as in the Philippines, as stated, the Philippines is not a persistent objector to the customary rules under the Mandela rules. And as to the third question, the Mandela rules qualify as proof of customary rules since the UN promulgated or these rules first in 1955, and it has been universally acknowledged. And also in 2015, the rules has been renamed to Nelson Mandela rules. And in such UN resolution, there has been no contention, and the UN states were in consensus, sir. So that is why the Mandela rules qualify as a proof of the customary international rules that I invoke in the relief I sought, sir.
Okay, thank you. For Aldrin, next slide. So you're focusing on the Philippine Rule PD 603,
Yes,
Child
sir.
and Youth Welfare Code. And Article 3, Paragraph 7 of the Child and Youth Welfare Code already guarantees a child's right to recreation, right? So maybe we can use that already as basis for obtaining this relief to prohibit private elementary school teachers from giving homework to the school children during weekends. Do we still need the CRC to obtain the relief that we want?
Yes, sir. I think there would be a need still for CRC because while PD 603 provides for protection and the right to recreation, it is the CRC which specifically provides for the child's right to rest and leisure. So taking into consideration the problem of students not having enough time to rest at large, I think CRC is needed to obtain the relief we are seeking, sir. To reiterate, sir, this is because even if the right to recreation or use of leisure hours is protected by PD 603, it is the CRC that specifically provides for the protection of the children's right to rest.
Okay, thank you very much. So we
you,
finished
sir.
the first 10 presenters for session 3. We're moving a bit slow. We need to finish 10 more before we end at 3 o'clock. Okay? So that was Mr. Sabas Aldrin. And now I'll invite Miss C. No? So Miss C, after you present, please sit here in front so you'll be ready to answer the questions.
Good afternoon, Attorney Palacios and my fellow J.D. students. I am Tony Macy, and I will be discussing today the lack of access to reproductive health services for women deprived of liberty under the Bureau of Corrections. So first, let me expound on the problem. The Bureau of Corrections runs the Correctional Institution for Women, or the CIW, the biggest facility for women inmates in the country, and it is currently holding over 3,000 women and counting. Yet, these 3,000 women are deprived of basic reproductive health services in two ways. First, there is no free access to menstrual pads, so they are forced to buy from the in-house store at a higher price compared to retail, or if they have no available funds, which is common for inmates, to make makeshift pads that can lead to infection. And second, there is limited to no access to medical services for those with gynecological conditions or are pregnant because of understaffing, as there are only 3 nurses assigned to the CIW despite holding over 3,000 women, and no regular doctors. Moreover, there is a lack of budget for medical equipment and supplies to conduct even basic checkups or to provide medicine not just for pain relief, but other necessary medical supplies, such as prenatal vitamins for pregnant women. So why is this a problem that cannot be solved solely under our domestic laws? The governing law is Section 4 of the Bureau of Corrections Act, which only provides for health and welfare programs. Its implementing rules and regulations refer to the administration of proper nutrition, hygiene, sanitation, cleanliness, and promotion of good health to inmates. As we can see, there is no specific and express provision for reproductive health services for women. This, in effect, leaves to the discretion of the wardens if they will provide reproductive health services. Unfortunately, the wardens of the Correctional Institution for Women have chosen, for at least 5 years, not to provide adequate reproductive health services, as there is even no specific budget for it in its appropriations. With this, I propose the application of the Convention on the Elimination of All Forms of Discrimination Against Women, or CEDAW, as a domesticated public international rule to provide the legal relief of compelling the Bureau of Corrections to provide reproductive health services. The Philippines is internationally bound to apply the provisions of CEDAW, as it is an international agreement that the Philippines has become a state party to after it was signed on July 15, 1980, and ratified on August 5, 1981. CEDAW was domesticated by way of transformation, as it was ratified by then-President Ferdinand Marcos in 1981, and subsequently concurred in by a majority of all members of the Batasang Pambansa as per the 1973 Constitution. Hence, CEDAW is on Tier 2 of the hierarchy of rules in the Philippine legal system, the same as statutory rules. So now that we have discussed the binding effect, we go to the substantive effect. Article 12 of CEDAW requires states to ensure, on a basis of equality of men and women, access to healthcare services, including those related to family planning. So what does providing access to healthcare based on equality mean? As per the General Recommendations number 24 of the CEDAW Committee, this means that women's equality is not just to provide the same access to healthcare for both men and women, as there are biological factors such as menstrual cycle and reproductive services that must be accounted for. So what will be the effect of CEDAW on the domestic rule? Article 12 of CEDAW, as a domesticated pill rule, will result in the reinterpretation of health and welfare programs under Section 4 of the Bureau of Corrections Act to also include reproductive health services for women deprived of liberty. With this interpretation, the state, through the Bureau of Corrections, has the positive duty to actively provide for reproductive health services to women deprived of liberty, rather than just leaving it to the discretion of the wardens if they will provide it. In conclusion, with both CEDAW and Section 4 of the Bureau of Corrections Act, women deprived of liberty may file a petition for mandamus as a legal remedy to compel the Bureau of Corrections to provide reproductive health services to women in their facilities. Thank you for your time, and may I introduce the next speaker, Ms. Samantha Villanueva.
Good afternoon, everyone. I am Samantha Villanueva, and today I will discuss my case study on the Convention on the Rights of the Child as basis to prohibit the parent from posting his or her minor child's photos and videos on social media. Most, if not all of us here, are aware of the phenomenon called sharenting. You may be following a TikTok account run by a mother documenting moments from her life with her toddler, or you may have come across a wholesome Facebook post of a parent sharing a photo of his newborn baby. Sharenting has been defined as the habitual use of social media to share news, images, and other information of one's children. Undoubtedly, children do not fully understand the consequences of their presence on social media, and they do not know that just like you and me, they too enjoy the fundamental right to privacy. According to the Constitution, the state shall defend the right of children to assistance, including special protection from all forms of exploitation, and other conditions prejudicial to their development. Sharenting exposes children to such conditions. It exposes a child to harassment and identity fraud. Furthermore, the digital footprint created about a child by his or her parents persists as a representation of them into adulthood. thus eroding their autonomy and self-determination. Because of the real threats of sharenting, and guided by the best interests of the child principle, I am seeking to prohibit parents from posting their minor child's photos and videos on social media. Currently, this relief is not provided by Philippine laws. Although the Data Privacy Act is a big leap in cultivating the culture of privacy in the Philippines, it does not address sharenting. Certainly, parents are not acting as data controllers whenever they share and disclose personal information of their children online. This kind of data processing can be perceived as related to personal, family, or household affairs, which is expressly excluded from the coverage of the Data Privacy Act. On the other hand, the Convention on the Rights of the Child expressly provides in Article 16 that no child shall be subjected to arbitrary or unlawful interference with his or her privacy. The right to privacy includes informational privacy, and this article is broad enough to protect the child not only from interference by strangers, but also from the danger which may be inflicted by parents due to the sharing of their child's personal information on social media. The second paragraph of Article 16 provides that the child has the right to the protection of the law against such interference or attacks. Thus, while parents may legitimately restrict a child's rights under Article 16, a state party also has an obligation to take measures which may interfere with the said parent's rights where this is necessary to secure a child's best interests. The Convention on the Rights of the Child may be a source of relief because first, the Philippine state is bound under international law to such rule. The convention was signed by the President on January 26, 1990, and the instrument of ratification was deposited on August 21 of the same year. It then entered into force on September 2, 1990 in the Philippines, and the country made no reservations when it consented to be bound by it. Second, the convention has been domesticated into Philippine law because the President signed the instrument of ratification and the Senate concurred in it on July 26, 1990. As the Convention on the Rights of the Child is on the same level as our statutes, it can be used to fill the gap in Philippine law with regard to defending the right to privacy of children on social media. The time is now to use a child-centered perspective on sharenting, and by recognizing a child's right to online privacy, we will be able to protect the future generations from the concrete harms caused by sharenting. Thank you for your time. Our next speaker is Mr. Agabin.
Good afternoon. So there is an unsustainable plastic production and consumption, as well as insufficient waste management infrastructure in the Philippines. For example, an estimated 2.7 million tons of plastic are produced every year, and this number is only expected to increase over time. As a result of these increasing numbers, recent development in regulations and in the industry have been focused on a circular economy approach, mainly on addressing waste and the use of recycled plastics with the intention of reusing them and keeping these materials in the value chain for a longer period of time. What these developments fail to address, though, is to completely address the production and manufacturing of plastics. In the production of plastics, hazardous additives are used during the production. These additives have not been subject to controls, nor have been recognized as allowable persistent organic pollutants, which are generally able to persist in environments for a long period of time. Besides being difficult to recycle, these materials are also harmful to the human health and as well as to the environment. Due to the nature and characteristic of these materials, when they are used in production, they do not break down completely and tend to build up in the environment. And research has also shown that these materials have been found inside humans and animals as well. Given this, I would like to use the Basel Convention on the Control of Transboundary Movements of Hazardous Waste and their Disposal as a basis to compel plastic manufacturing companies to reduce the use of hazardous additives. The Basel Convention provides in Article 4.2a that the parties to the convention shall take the appropriate measures to ensure that the generation of hazardous waste and other waste within its or other waste within it is reduced to a minimum, taking into account social, technological, and economical aspects. So the Philippines is a signatory to the Basel Convention, and it was domesticated by transformation when it was conferred in by the Senate in March 10 of 1993. Thus, the Philippines is bound under this rule internationally and locally, and has the same effect and level as the statute. On the other hand, the prevalent Philippine rule is RA 11898, which an act institutionalizing the extended producer responsibility on plastic packaging waste. Section 6 of this rule provides that obligated enterprises shall establish or phase in EPR programs for plastic packaging to achieve efficient management of plastic package waste, reduce production, importation, supply, or use of plastic packaging deemed low in reusability, recyclability, retrievability, and plastic neutrally through efficient recovery and diversion schemes. A reading of both rules shows that there is a gap between the international and the Philippine rule, since the latter lacks rules regarding the production of plastics itself. It does not limit the use of the hazardous additives, as it focuses mainly on the reduction of the amount of plastics produced and the recycling of such plastics. I would argue that substitution in this case would be a better solution compared to a total ban, since a total ban isn't always feasible. There is a lack of research as to the toxic additives in which substitutes are not always the best solution, since they may also be harmful cousins to these additives. The international rule would fill the gap in the current law, and it would have a different approach to the problem by making way for rules and regulations that will limit and regulate the use of hazardous additives in the production of plastics. This ends my presentation, and I would like to call the next presenter, Ms. Burdin.
Hello. Okay. Good day, everyone. The problem I seek to address with the aid of international law is that stray dogs in Bakakay, Albay are not evacuated during typhoons. To further illustrate, imagine a young boy named Potpot who lives in a coastal barangay in Bakakay with his family, and he feeds this stray dog he named Blackie with leftovers as much as he can. One day, a typhoon threatens to make landfall in Albay, prompting Pag-asa to raise signal number 2 there. In the midst of heavy rains, Potpot and his family were asked to evacuate by the LGU for their safety. Potpot saw Blackie sitting there in the rain with confusion reflected in the dog's eyes. Potpot really wanted to bring Blackie with him to the evacuation center, but the LGU rejected his request, stating that people are to be prioritized, not animals. Under Philippine law, specifically RA 8485, can we compel the Bakakay LGU to evacuate Blackie as well? I'm afraid not, because if you look at Section 6 of the law on the screen, it only speaks of neglect, and neglect is too broad of a term to contemplate scenarios like this. We then look into international law, and the Convention on Biological Diversity, CBD for brevity, gives us hope regarding Blackie. The CBD is the international legal instrument for the conservation of biological diversity. Its formal source is treaty making, and its material source is the text of the CBD itself. It is binding on the Philippines because the state complied with the formalities prescribed by the agreement in becoming a party thereto, namely signature and ratification of the treaty. Particularly, the Philippines signed on June 12, 1992, and former President Fidel V. Ramos ratified it on May 31, 1993. CBD forms part of our domestic law via transformation when the Senate actually concurred in the ratification on October 5, 1993, pursuant to Article 7, Section 21 of the 1987 Constitution. By virtue thereof, CBD in the form of a treaty has the same status as a statutory rule. And with respect to RA 8485, as mentioned earlier, CBD does not actually present a conflict and instead fills a gap in the said law by providing a solution to the problem in this case. Specifically, CBD can be used as basis to compel the Bakakay LGU to evacuate stray dogs like Blackie during typhoons. Indeed, Article 8D of the CBD, as you see on your screens, does not provide specific relief. However, interpretation of the CBD using the Vienna Convention on the Law of Treaties leads us to the right direction. And Article 8 of the CBD is entitled In Situ Conservation. And you can see the definition of in situ conservation on your screen as the conservation of ecosystems and natural habitats, among others, and in the case of domesticated or cultivated species, in the surroundings where they have developed their distinctive properties. The CBD actually doesn't miss because it also defines domesticated or cultivated species in which is a species in which the evolutionary process has been influenced by humans to meet their needs. And based on my research, domestic dogs are classified into 3 categories, one of which is the stray or vagrant ones, which have no home and no owner but adhere to the human environment for food and shelter. By inference, the stray dogs actually fit into the CBD's definition of domesticated or cultivated species. Now, what's the relevance of this? Pursuant to Article 31, Number 1 of the Vienna Convention on the Law of Treaties, a treaty shall be interpreted in good faith and in accordance with the ordinary meaning to be given to the terms of the treaty, in their context and in light of its object and purpose. Thus, the CBD's definition of in situ conservation should be interpreted to embrace stray dogs as well. In other words, they should be evacuated during typhoons in line with the main objectives of the CBD to conserve them in the surroundings where they have developed their distinctive properties, in this case, the communities. To conclude, the Convention on Biological Diversity can be used as basis to compel the LGU of Bakakay Albay to evacuate stray dogs during typhoons. Hence, Blackie, in our scenario, would not be left behind. Thank you for your time, everyone. Please welcome our next speaker, Mr. Cadiz.
Good afternoon, everyone. Today, I will be discussing the damage invasive feral cats cause to native wildlife. Consider the following. After humans, the biggest threat to native tarsiers is the invasive cat. In Bohol, there is a private forest reserve which is home to 100 tarsiers. In order to protect the tarsiers, the rangers of the reserve shoot dozens of cats entering or roaming within it. However, the rangers lament that they are unable to stop the invasive cats at their source, the surrounding LGUs. For their part, the LGUs refuse to control or eradicate the invasive feral cat population, citing the lack of a legal basis. They argue that although the release of exotic species is prohibited under Philippine law, there is no mechanism from domestic sources that compels LGUs to control the populations of invasive species, such as cats, once released. In other words, there is a gap. Section 8 of the Convention on Biodiversity fills in the gap in the Philippine law by compelling state parties thereto to, as far as possible and as appropriate, prevent the introduction of, control, or eradicate those alien species which threaten ecosystems, habitats, or species. The formal source of the CBD is the treaty-making process. The material source is the text of the CBD itself. This treaty is binding on the Philippines under the international legal system because the Philippines is an original party to the Convention on Biodiversity that gave its express consent to be bound by the convention. And according to the book, Philippine Treaties in Force by Ambassador Ed Malaya, the Convention on Biodiversity was adopted at Rio de Janeiro on the 5th of June 1992, signed by the Philippines on the 12th of June 1992, and ratified by the President on the 31st of May 1993. The treaty has also been domesticated into a Philippine legal rule in the Philippine legal system by transformation. This occurred because the CBD was, again, ratified by the President on the 31st of May 1993, concurred in by the Senate on the 5th of October 1993, and pursuant to the requirements in the treaty, an instrument was deposited by the Philippines, on the 8th of October 1993. Hence, the convention is part of the Philippine law and at the level of a statute. Thus, LGUs may be compelled through a special civil action for mandamus to perform its duty under Article 8 of the Convention on Biodiversity to control or eradicate invasive cat populations in order to protect native species such as the tarsier. Thank you for listening. Our next speaker is Ms. Pauline De Leon.
Okay, I'll ask you the questions. So for Tony, right? You're invoking the CEDAW. So we know that we already have Philippine legal rules that provide for, and you mentioned them here, no? Bureau of Correction. So we have provisions already in the Constitution guaranteeing protection to women. We also have a statute, Magna Carta of Women, and also we have the RH law. This latter law seems to pertain to the reproductive health of women. Can't we just rely on those Philippine legal rules to obtain the relief that you seek? Do we really need CEDAW, Article 12.2?
Thank you, sir. So, unfortunately, Philippine laws are not sufficient in themselves as they do not all provide for the active duty for reproductive health services for all women. So, for example, sir, the RH law, or the Responsible Parenthood and Reproductive Health Act of 2012, unfortunately only applies to LGUs and public hospitals, so it would not apply to the Bureau of Corrections. And as for the Magna Carta of Women, it only specifically ensures access to services for women who are pregnant or who have gynecological conditions. So for women who do not have those specific circumstances but still have reproductive health concerns, they would not be covered by the insurance of services under the Magna Carta. And as for the Constitution, sir, I argue that it is not specific enough to provide for a positive duty to the Bureau of Corrections, as it is broad in its wording, and this might support the problem under the current rules, wherein it is the warden who has the discretion to provide for good health, which may or may not, according to the warden, include reproductive health services.
Okay, thank you.
Thank you, sir.
So for Sam, so your case study is about sharenting. You already have this constitutional provision which protects the child from exploitation, right? And also you have the Data Privacy Act. Those are the relevant Philippine legal rules. Do we still need CRC?
Thank you for your question, sir. We still need the CRC to provide my relief because first, the constitutional provision on the special protection from exploitation is not self-executing. Jurisprudence provides that a constitutional provision is self-executing if the nature and extent of the rights conferred as well as the liability imposed are fixed by the Constitution itself. I respectfully submit, sir, that the extent of protection to be provided by the said provision as well as the liability to be imposed in case a person causes a child to be subjected to conditions prejudicial to their development is not fixed by the Constitution, especially in light of the circumstances right now wherein technological innovation contributes to the exploitation of children. So it is my submission that the provision is merely a statement of principle or policy of the state. Likewise, the Data Privacy Act cannot be a source of my relief because it excludes from its coverage the processing of information in relation to an individual's personal, family, or household affairs. I submit, sir, that that sharenting falls under that type of processing. So, as such, I propose, sir, that the convention, that the CRC be used as a source of my relief because it imposes an obligation on the states to provide positive measures to secure a child's enjoyment of their right to privacy.
Okay, thank you.
Thank you, sir.
So for Diego, you're using the Basel Convention Now, the Basel Convention seems to be an old international agreement. It was domesticated in the 1990s, is that correct?
Yes, sir.
And second, the Basel Convention provisions seem to be broadly worded. They refer to hazardous waste. And instead, you have this new statute, RA 11898, which is newer and more specific. So why do we invoke the Basel Convention and not this statute?
Sir, I would argue that the Basel Convention can still be invoked because it addresses a gap that the newer law, which the newer law fails to address. So the first among this gap is that the newer law, although it provides provisions for the recycling and the reduction of plastics, it fails to address the technicalities of the production of the plastic making processor. So that's one of the gaps that the Basel Convention can address. And secondly, while the newer law addresses the problem of plastics in general as a pollutant, the Basel Convention can be used in order to recognize that the production of plastics as well is also as harmful as the plastics itself.
Okay, thank you. So for Ayla, the relief that you want is protection for stray dogs,
Yes,
right?
sir.
And it seems that the Philippine statute RA 8485 already protects the stray dogs from neglect, which would happen if they're left behind. So it seems that this statute is more appropriate as basis for the relief that you seek instead of the Convention on Biodiversity, which refers to protection of ecosystems. Right, so that's one. It
Yes,
seems that the statute is more appropriate. And second, if we invoke CBD, maybe we are taking away the dogs from their ecosystem. So I don't know, is that correct?
Thank you for the question, sir. So, RA 8485, sir, does not really provide the solution that I am going for. More than neglect, sir, providing care, sustenance, or shelter, I am aiming for the conservation, sir, of the domesticated or of the stray dogs or the domesticated or cultivated species, sir, in the surroundings where they have developed their distinctive properties. And this is provided, sir, by the CBD in its Article 2. And actually, Article 8D, sir, is merely an aspect of the entire in situ conservation of the entire Article 8. And moreover, sir, evacuation is merely temporary. So it entails returning them after the typhoon has passed. So it is in line with conservation as opposed to not evacuating them and leaving them to die, sir.
Thank you.
Thank
you. So for Mr. Cadiz, as next slide. So here you pointed out that there is a gap, right? Because the Philippine rule prohibits introduction, but it does not obligate the eradication, right? Okay,
Yes,
so
sir.
there's a gap in Philippine law, and that's being filled by this Convention on Biodiversity. Do you think that there's a clear obligation when the language of Article 8 says as far as possible and as appropriate? Seems to soften that obligation.
It does seem to soften the obligation, sir, but I would argue under the Vienna Convention on Laws and Treaties, Article 26, there needs to be good faith compliance with treaties. And in this case, the Philippines, which has done nothing, cannot argue good faith. The as far as possible and as appropriate is usually interpreted as giving the party state some discretion to decide whether or not it is financially capable of pursuing such a solution. But in this case, no solution has been pursued whatsoever. Therefore, they can be compelled to do something. And in this case, this is what I am attempting to compel them to do.
Okay, thank you. What we'll do is we'll take a break here. We're supposed to have a break at 3 o'clock, right? So we'll take a break now, and then we'll resume at 3:15. Okay? So thank you, and see you again at 3:15. Welcome back to our Junior Scholar Symposium on Public International Law. This activity is organized by the UP College of Law and supported by the Philippine Judicial Academy, the Legal Education Board, the Integrated Bar of the Philippines, the Philippine Association of Law Schools, and the Philippine Society of International Law. This is the 5th edition of the symposium, and today we are now on our 4th and last session. We have heard the case presentations by 35 presenters, and we are down to our last 20 presenters. So stay with us until 5:15. So for our 36th presenter, I'm going to invite, who is this? Okay, Mr. or Miss Berdin. Her topic will be on environmental law, right? Sorry, where's Miss Berdin? Ah, you finished already? Okay, wait. 36th pala yan. 38th na. Miss De Leon on dolomite.
Good day, everyone. I am Pauline De Leon, and I'll be discussing the Philippine law problem that I have identified, which is the washing off of dolomite sand from the Manila Bay beach is akin to dumping foreign sediments, which can pollute marine biodiversity in Manila Bay. The Dolomite Beach project started when the Supreme Court issued a writ of continuing mandamus in the case of MMDA versus concerned residents of Manila Bay. In that case, government agencies were directed to spearhead the rehabilitation of Manila Bay. Thus, the DENR came up with a beach nourishment project wherein dolomite sand was poured on Manila Bay's shoreline. The project received a lot of criticisms from various environmental groups, and notably, the UP Marine Science Institute found that dolomite sand will erode due to the hydrodynamic conditions in Manila Bay during storms. And once eroded, the dolomite would be washed off to Manila Bay seabed, causing pollution. This actually happened in November 2020 when typhoons caused portions of the artificial beach to be washed out to the Manila Bay seabed. Some of the adverse effects of dolomite sand in the marine environment are it buries the marine biodiversity, it lowers the oxygen in the seawater, and it blocks their access to sunlight. Indeed, the addition of dolomite sediments only worsens Manila Bay's deterioration. Here, the United Nations Convention on the Law of the Sea, or UNCLOS, can be applied by Philippine courts to address this Philippine law problem. Here, the Philippines is a state party to the UNCLOS, for it was signed and ratified by the Philippine state. Moreover, UNCLOS has been domesticated into the Philippine legal system by way of transformation under Article 8, Section 14.1 of the amended 1973 Constitution by virtue of the National Assembly concurrence on March 26, 1984. In turn, UNCLOS is binding on the Philippines, and it has the same status as a statutory rule, being on the second tier in the hierarchy of rules in the Philippine legal system. In this case, UNCLOS filled the temporary gap in the Philippine legal system by creating a new Philippine legal obligation to prevent pollution by dumping. Here, the UNCLOS and the Clean Water Act do not have conflict per se. Section 4L of the Clean Water Act provides that dumping means any unauthorized or illegal disposal into any body of water, waste or toxic or hazardous material, while Article 1.5 of UNCLOS provides that dumping means any deliberate disposal of waste or other matter at sea, and also it is dumping under UNCLOS if the placement of a matter not for mere disposal is contrary to the UNCLOS aims of preventing pollution by dumping. It is clear from the provisions that the Clean Water Act does not include dolomite sand, while under UNCLOS it is included. In effect, UNCLOS fills in the gap as to the definition or coverage of dumping. Moreover, Article 26 of the VCLT, of which Philippines is a party, embodies Pacta Sunt Servanda, wherein Philippines must comply with UNCLOS treaty obligations in good faith. Moreover, as per as per Article 27 of the VCLT, a party may not invoke the provisions of its internal law as justification for its failure to perform a treaty. It is to be noted that Article 210 of UNCLOS provides an obligation wherein states shall adopt laws and regulations and shall take other measures as may be necessary to prevent, reduce, and control pollution of the marine environment by dumping. And the word shall here connotes a mandatory obligation. Thus, all measures shall be undertaken to prevent or control marine pollution by dumping, and such measure include the removal of dolomite sand. UNCLOS then can be applied as basis to compel DENR to remove the dolomite sand in Manila Bay, because Philippines must abide by its treaty obligations under UNCLOS by preventing marine pollution by dumping. So that concludes my submission. Thank you everyone for listening and for your time. And I now give the floor to Mr. Fortunato Madamba.
Good afternoon, everyone. I am Renz Fortunato Madamba, and my case study revolves around the problem of overconstruction in major tourist destinations, specifically in the island of Boracay. I believe we can all agree that the environment is something worth protecting. But when you think of the environment, what does it really represent? Usually, people think of virgin islands, lush forests, and wide open farmlands. The reality is that these natural wonders are now polluted with large resorts, rows of souvenir stalls, and crowds of people. Recently, there was controversy about large casinos starting construction on the shores of Boracay. People protested, voicing concerns on how these large casinos would affect the ecosystem as well as the overall atmosphere of Boracay Island. Every year, we hear about how thousands of people flock to the island, going over the limit of how many people it can actually accommodate. Does it really need one more resort? But what can one do against multinational corporations? How can we prevent the corruption of the Philippine Islands? With the use of an international law, namely the ASEAN Tourism Agreement, I would like to prohibit an LGU such as the LGU of Boracay from issuing building permits in culturally and environmentally sensitive tourist destinations. Currently, our building code only requires a general standard for buildings, whether or not they're in sensitive locations like in my case study in the island of Boracay. There are a couple of executive orders which prohibit projects that would environmentally impact specific areas. However, these projects which require an additional environmental impact assessment are limited to two things, which are mining and reclamation. Although not recognized by Philippine law, these tourist destinations are also a national resource, and construction in these zones should also be regulated with equal enthusiasm. This is a gap in the Philippine law that could be supplemented by an international law. The ASEAN Tourism Agreement was signed in 2001, ratified by former President Arroyo in 2003, and entered into force in 2007. Thus, it was domesticated by transformation. Although there is no Senate concurrence, the law is equivalent to executive relations, procedural rules, or local ordinances, thus binding upon the state to fill a gap in the Philippine law. The text of the treaty encourages the Philippines, especially at the local government level, to ensure the preservation of our natural heritage. It is the role of the state to apply the provisions of this treaty to ensure the participation of the local government in protecting our environmentally and culturally sensitive tourist destinations. Even though the provision uses the word encourage, looking at Article 9 in the same treaty, it states, and I quote, "Member states shall draw up necessary protocols, memorandum of understanding, or any other instrument to carry out the provisions of this agreement." This imposes a positive obligation on the state parties to follow through with the provisions of this treaty. In line with the national intent of protecting the environment by prohibiting mining and reclamation projects which do not comply with the additional environmental impact assessment, The excessive, destructive, and possibly irreversible construction in major tourist destinations such as Boracay should be prohibited. If this relief is granted, it shall serve as precedent for the protection of other major tourist destinations like Siargao, La Union, Palawan, Baguio, and Iloilo, to name a few. I hope to see you all there soon on the battlefield against overconstruction in major tourist destinations. Thank you for your time. Our next speaker is Ms. Isabella Martinez.
Good afternoon. I will be discussing how the Philippines can use the Vienna Convention on road traffic as a basis to prohibit the purchase of sirens for purposes other than using them for emergency vehicles. Despite the fact that sirens, more popularly known as the wangwang, may only be used for emergency vehicles, civilians are allowed to purchase the same for their own personal use, even if prohibited under RA 4136 or the Land Transportation and Traffic Code. Under this law, every motor vehicle shall be provided with a horn or signaling device in good working order, provided, however, that no horn or signaling device emitting an exceptionally loud, startling, or disagreeable sound shall be installed or used on any motor vehicle. All authorized emergency vehicles, such as ambulance, police cars, and fire wagons, used for emergency calls, shall be equipped with a bell, siren, or exhaust whistle of a type approved by the Commissioner, and no such device shall be installed or used in any other vehicle. In his 2011 State of the Nation address, the late former President Noynoy Aquino recognized not only the problem of illegal sirens, but also the culture it perpetuates. He equated the use of the wangwang to a mindset of entitlement. To illustrate, Maria, a third-year student, is driving to school. As she's driving, she eventually reaches the highway where traffic is at a standstill. It seems that there is an accident up ahead. Suddenly, she hears a siren. As is common practice, she tries to position her car in such a way that it would not block what she presumes to be an ambulance. Then, she sees Pedro's car using the siren. Much like Maria, he is also headed to school. Unlike Maria, Pedro's parents are powerful people. They bought a siren so that they never have to sit in traffic and miss a meeting. Pedro uses the siren to cut through traffic. To solve this issue, under international law, there is the Vienna Convention on Road Traffic, or the VCRT. Article 7 of the said convention provides that drivers shall take care that their vehicles do not inconvenience road users or the occupants of properties bordering on the road, for example, by causing noise or raising dust or smoke, where they can avoid doing so. The convention also goes further by obligating road users to avoid behavior likely to endanger or obstruct traffic, to endanger persons, or to cause damage to public or private property. The VCRT was created through treaty making, and the source of it is the text of the convention itself. The convention was signed by the Philippines in 1968, and it was then ratified by then President Marcos in July 1973, pursuant to his power under Article 14, Section 16 of the original 1973 Constitution. The instrument of ratification was deposited on December 1973, thus complying with Article 45 of the Convention and making the same binding on the Philippine state. This being the case, the VCRT is on the second tier and is on the same level as a statute. The rule has no conflict with any existing Philippine laws. As a matter of fact, it would fill a gap. Article 7 of the Convention would strengthen the implementation of the Land Traffic and Transportation Code. While the VCRT imposes the obligation not to inconvenience other road users by causing noise and obstructing traffic, it does not outrightly prohibit the purchase of illegal sirens. However, it should be noted that these sirens fall under what Section 7 of the VCRT explicitly disapproves of, being the tools used to inconvenience and endanger. Thus, applying the Vienna Convention on the Law of Treaties, Article 31, Number 1, which provides that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty, in their context and in the light of its object and purpose, there is clearly a basis to prohibit the purchase of sirens. After all, why are private persons allowed to purchase these sirens if the resulting act would be illegal? By prohibiting the purchase of the sirens, the Philippines would be staying true to its word under the VCRT. Specifically, it cuts off the problem at its source. By applying the said convention, soon enough, people like you, me, and Maria don't have to get cheated out of something as simple as equal use of a road. That would be all for my case study. Thank you so much for listening. I would like to introduce the next speaker, Ms. Renzi Ayap, to begin our discussion on labor law.
So good afternoon, everyone. I'm RC Ayap, and my case study is about the International Covenant on Economic, Social, and Cultural Rights and how it can be used as basis to protect the right of a freelancer to Social Security, particularly by compelling employers to contribute to a freelancer's monthly premium payments to PhilHealth. So currently, employers do not contribute to the PhilHealth premium of freelancers. This is because freelancers are not entitled to receive social welfare benefits from their employers under our present labor laws. Thus, unlike a regular employee who has an employer shouldering half of his PhilHealth premium, a freelancer needs to pay the full amount of his premium. So for instance, a freelance photographer who is sometimes hired by an event management company, if he suddenly gets sick, for example, and needs to be hospitalized, he can only enjoy the benefits granted to PhilHealth members if he registered as such beforehand. But he needs to pay the full amount of his premium. Under the Labor Code, Article 166 provides that the state shall promote and develop a tax-exempt employees' compensation program. So for this purpose, the government provides social welfare services through SSS, GSIS, Pag-ibig, and PhilHealth. And to ensure that everyone has access to these services, employers and employees are required by law to contribute to these agencies through salary deduction. So for PhilHealth, the monthly contributions are deducted from the employee's actual monthly salary, where they are required to contribute 50%, and the remaining 50% should be paid by the employer. But since freelancers are not considered as employees within the meaning of the law, for a freelancer to avail the social welfare benefits, he needs to apply for membership voluntarily as a self-employed worker, which means that he needs to pay by himself the full amount of monthly contributions. Thus, to compel the employer to contribute to a freelancer's monthly premium payments to PhilHealth, we can use the International Covenant on Economic, Social, and Cultural Rights as basis. So this covenant provides for the recognition of the right to work, which includes the right of everyone to the opportunity to gain his living by work which he freely chooses or accepts. So it is my proposition that this should include freelance works. In particular, Article 9 recognizes the right of everyone to Social Security, including social insurance, and by everyone, this should include freelancers. The state then, to safeguard this right, should give freelancers the same rights and benefits as regular employees, including the right to receive social welfare benefits like PhilHealth. And while Article 2.1 of the said covenant softens the state's obligation to guarantee these rights, since it provides that each state party to the maximum of its available resources, with a view to achieving progressively the full realization of these rights, it's still my proposition that recognizing the right of a freelancer to receive social welfare benefits will not be burdensome to the state. After all, a freelancer, like a regular employee, will still pay for his own contributions. What the state's obligation here is to compel an employer to recognize that right so that a portion of these contributions will be paid by the employer. This can be done, for example, by giving additional compensation, which is separate from the salary and which will only be used to pay for PhilHealth premium. So the formal source of the covenant is the treaty-making process, and the material source is the text of the covenant itself. And the Philippine state is bound under international law to the ICECR because we are a party to the said covenant. So it was domesticated through transformation. It was signed in 1966 and ratified in 1974. And entered into force generally in 1976. Although there was no concurrence by the majority of all the members of the National Assembly as required by the 1973 Constitution, Article 14, Section 16 states that the Prime Minister may enter into international treaties or agreement. Thus, it is still in the same level as a statute in the Philippine legal system. The effect of its domestication, therefore, is that it fills a gap in the Philippine legal system, since prior to it, Philippine legal rules do not provide for a freelancer's right to receive social welfare benefits like PhilHealth, whereas the ICESCR provides for such legal right. That's all for my presentation. I now call on the next presenter, Mr. Carriaga.
Good afternoon. So the problem in my case study is that private regular employees are not entitled to sick leave. So in the scenario that a private regular employee is not granted a sick leave under a collective bargaining agreement or through the generosity of his or her employer, a private regular employee cannot mandate the employer to grant him his or her sick leave under labor laws of the Philippines. So the relevant Philippine rule in my case study is Article 95 of the Labor Code, which states that every employee who has rendered at least 1 year of service shall be entitled to a yearly service incentive leave of 5 days with pay. So it is evident from Article 95 that it makes no mention of granting of sick leave. So in order to demand the sick leave, we can use the international rule found under the International Covenant on Economic, Social, and Cultural Rights, or ICESCR, specifically Article 12.2, which states that the steps to be taken by the state parties to the present covenant to achieve the full realization of this right shall include those necessary for the creation of conditions which would assure to all medical service and medical attention in the event of sickness. So this rule is binding on the Philippines in the international legal system, since we were an original state party and we signed the treaty in 1966 and it was ratified in 1974. And then it was domesticated through transformation when President Marcos Sr. Ratified it in 1974 under the 1973 Constitution, pursuant to his Prime Minister powers found in Article 14, Section 16 of the 1973 Constitution. Now, it is my submission that using Article 12.2 of the ICESCR, it can be used as a basis to compel the private employer to grant sick leave, since to grant sick leave would be to create the condition of which to assure medical service and medical attention to the private regular employee. So thank you. That's my presentation. I would like to call on the next presenter, Ms. Chica.
A pleasant afternoon to everyone. For my case study, I will be presenting how the Convention on the Rights of the Persons with Disabilities can be used as a basis to compel the employer to give PWD employees yearly medical leave of 2 days with pay. Let's have a hypothetical situation here. Sheila is a PWD employee at Malaya Incorporated. She was diagnosed with a hearing impairment and was required to use a pair of hearing aids. Since it is considered a lifetime condition which requires a semi-annual check-up to ensure that her condition will not get worse. Among the 100 rank-and-file employees of the said company, 10 are regular PWD employees. Each rank-and-file regular employee has 6 service incentive leaves. In March 2021, there was a flu outbreak in communities where some of the employees lived. Several employees opted to use their leaves to cover the days that they were not able to render work. Among those employees are the 10 PWDs. Sheila has a semi-annual checkup scheduled in June of the same year. Since she had already used her leave credits, she was hesitant to go to her scheduled health checkup since it will require at least one whole day for the test and another day for the assessment or the diagnosis, and it will be deducted from her expected salary. Sheila skipped the checkup for fear of having absences that will result in her salary deduction. Her monthly salary is enough to cover her and her family's expenses. After 2 months, Sheila's condition got worse. She experienced total hearing loss for days. It resulted in her not being able to render work efficiently. Sheila realized that PWD employees like her should be given additional leave credit for medical purposes. Unlike normal employees, PWD employees possess special conditions that will require maintenance or regular assessment. The problem in this case is that there is an inadequate yearly and service incentive leave for PWD employees. Thus, this is my proposition that there is a need to compel the employer to give PWD employees yearly medical leave of 2 days with pay. Under Article 95A of the Labor Code, every employee who has rendered at least 1 year of service shall be entitled to a yearly service incentive leave of 5 days with pay. However, under Article 27I of the CRPD, it states that the promotion of the employment of PWDs should be ensured by the state by ensuring that reasonable accommodation is provided to them in the workplace. The CRPD is an international agreement to which the Philippines is bound as a state party, which it signed on September 25, 2007, and the instrument was deposited on April 15, 2008. It was domesticated into Philippine legal system through the principle of transformation. However, there is no concurrence of the state making it a mere executive agreement under the Philippine law. Being a state party in the CRPD, the Philippines is bound to comply with this obligation in the said international agreement, in good faith, following the object and purpose of the said international agreement. CRPD can be used to fill in the gap in the Philippine legal system by creating a legal right that protects and promotes the employment of PWDs by ensuring that reasonable accommodation is provided to them in the workplace. Reasonable accommodation is any change to the application or hiring process, to the job, to the way the job is done, or to the work environment that allows a PWD who is qualified for the job to perform the essential functions of that work and enjoy equal employment opportunities. In a recent study in the US, the new Center for American Progress Analysis of the 2018 Family and Medical Leave Act Employee Service found that a paid family and medical leave program that includes job protection is critical to helping disabled people enter the labor market and stay employed. If workers with disabilities have access to a job-protected paid family and medical leave program, they know that they can take paid leave without stigma or fear of retaliation. By reading the text of CRPD, it is a mandatory requirement that the state parties should safeguard and protect the rights of PWDs to just and favorable conditions of work. In other words, the state should be more proactive in giving the PWDs the chance to work while securing that they will still be able to prioritize their health and welfare. In reality, these PWDs need a continuous assessment and consultation regarding their condition because, more often than not, their disabilities will be a lifetime concern. If the employers will be compelled to give PWD employees additional medical leave for at least 2 days, it will be a means for the state to further the promotion and protection of the rights of PWDs by ensuring that reasonable accommodation is provided to them in the workplace. That's all. Thank you. For the next presentation, may I call on Mr. Colloquio.
Good day, everyone. I'm here to present on my case study on using the ILO Discrimination, Employment, and Occupation Convention as basis to prohibit employees from refusing to hire single mothers on basis of their status. Let's paint an imaginary scenario. Maria is a single mother. She is a recent college graduate, and she submitted many job applications for various employers. However, she was rejected by all the employers she sent applications to because the employers believed Maria would be a less efficient worker due to being a single mother. Thus, she entered the informal job sector, and somewhere along the way, she was assigned to be a drug mule to Saudi Arabia. She was caught by the authorities there and was executed for drug trafficking, as drug trafficking is an offense which that is punished by the death penalty there, which means her child grew without a father and a mother. According to the WHO, the Philippines has 15 million solo parents, 14 million of whom are solo mothers. This represents a large amount of about 100 million inhabitants of the Republic of the Philippines. And to this day, single mothers face discrimination in the hiring practices of employers, which leads to a lower quality of life, or sometimes having to take jobs in the informal sector, like Maria, as I mentioned, which could lead to very grisly fates, as I previously painted in the scenario. The Labor Code and the Solo Parents Act both protect solo parents with regards to terms and conditions of employment. However, it does not protect from employers simply refusing to hire applicants on jobs on the basis of them being single mothers. After all, if an employer does not want to give the benefits to single parents stated in the Solo Parents Act, as they only protect the terms and conditions of employment that a single mother is entitled to, they can just simply choose not to hire single mothers. Thus, I introduce here the ILO Discrimination, Employment, and Occupation Convention, which will be referred to as the Discrimination Convention for brevity. It defines discrimination as any distinction, exclusion, or preference made on the basis of race, color, sex, religion, political opinion, national extraction, social origin, or other such distinctions which nullify or impair equality or opportunity or treatment or employment in occupation. And it says each member of the convention, each member for which the convention is enforced, undertakes to declare and pursue a national policy designed to promote equality of opportunity. The formal source is the treaty, which is the ILO Discrimination Convention, and the material source is the text of the article itself. It is binding upon the Philippine state under international rule as an international agreement, which the Philippines is a party to. So, the international treaty was concurred in by the Senate in the Senate Resolution number 260, series of 1958, and was ratified on 17 November 1960 under the 1935 Constitution, and therefore, the ILO Discrimination Convention is in the same level as a statute when it comes to Philippine laws. The effect of this law is to fill a gap in the rules of the Republic of the Philippines in order to cover protections for single mothers, not just to terms and conditions, but also to ensuring equality of opportunity for them in the first place. And thus, it seeks to prohibit employers from refusing to hire single mothers on the basis of their status. That is all. Thank you very much. I would like to invite our next speaker, who is Miss Angelica Gabriel Gabinete.
Today, I seek to address the scheduling of 24-hour duties for resident trainee physicians. It is common for these residents, regardless if from a public or private hospital, to have 24-hour duties scheduled at least once a week. The frequency of this duty schedule varies between institutions and departments. For example, PGH first and second year neurology residents have them every 3 days. The schedule of a resident is denominated as pre, duty, and from. However, these are merely labels for internal reference. The residents would be working during those times. Let's look at Kylie, a second-year resident in XY Medical Center's General Surgery Department. Her schedule for the week is as follows. Pre, Monday 8 a.m. to 5 p.m. Duty, Tuesday 8 a.m. to Wednesday 8 a.m. from Wednesday 8 a.m. to 5 p.m., and following the same pre, duty, and from schedule for Thursday to Sunday. Meanwhile, Kylie's contemporary Marion, a first-year anesthetics resident in PR City General Hospital, has the same pre and duty schedule, but her from schedule is until 12 noon. Going back to Kylie, let's say at 9 a.m. during her from, she was directed by the consultant to cauterize a certain area. At this point, she is already at hour 25 of her duty schedule and has been awake for at least 30. Due to the resulting decreased hand-eye coordination from the sleep deprivation, she missed the intended tissue and burnt the consultant and two other nurses, who suffered third-degree burns. Under the omnibus rules implementing the labor code, the hours of work mandate applies to all persons employed by any hospital or clinic. However, there is no employer-employee relationship between the resident physicians and the training hospital if the resident physician is participating in a duly accredited training program. Since Kylie and her fellow residents are under the residency training program, they cannot be protected by the Labor Code's hours of work mandate. The ILO Promotional Framework for Occupational Safety and Health Convention shall be the basis to prohibit hospital training programs from scheduling 24-hour duties for these residents. Article 3 of the convention provides each member shall promote and advance at all relevant levels the right of workers to a safe and healthy working environment. The formal source is the treaty-making process, and the material source is the text of the convention itself. Under Article 8 of the convention, it is binding on ILO members who registered the ratification with the Director General of the IL Office and comes into force 12 months from the date of such registration. The Philippines became a member of the ILO in 1948. The convention was ratified by the President on June 13, 2019. It was domesticated following the transformation clause under the Constitution when it was concurred in by the Senate on June 17, 2019. And subsequently, it entered into force in the Philippines on June 17, 2020, a year after it was deposited with the IL office. The convention occupies Tier 2, the same level as Philippine statutes. There is currently no law nor any mandate from regulatory agencies prohibiting the scheduling of 24-hour duties for resident trainee physicians. This convention fills that gap. The convention provides a legal basis to prohibit such dangerous practice. Among the effects of 24-hour sleep deprivation are altered perceptions and an increased risk of accidents. Studies have shown that 24 hours of wakefulness is akin to having a blood alcohol concentration of 0.10%. For reference, the legal limit to drive in the Philippines for non-professionals is 0.05%. Forcing them to work in their sleep-deprived state creates a plethora of occupational safety and health hazards, not only for the residents themselves, but also for the hospital staff around them. Putting hospital workers in such peril contravenes the obligation under the convention to promote and advance the right of workers to a safe and healthy working environment. If the COVID-19 pandemic has taught us anything, it is that medical professionals are indispensable to the well-being of the nation. The physician shortage issue will not be resolved by exhausting Kylie, Marion, and all the other resident trainee physicians who are simply trying to give as much as they can to their patients. It only serves to create more problems. Thank you. I would now like to introduce the next speaker, Mr. Gonzaga.
Good afternoon, everyone. My topic will revolve around the huge discrepancy between the maternity and paid maternity and paternity leaves afforded to employees in the Philippines. Imagine having a child in this day and age. Now imagine being a male counterpart to the relationship and not being able to spend more time with your newly formed family, other than the 7 days afforded to you by law as you're badgered by work that you need in order to provide for them. It is for this hypothetical scenario that the relief I seek is to compel employers to allow paid paternity leave up to the same duration as maternity leaves. The relevant Philippine rule that dictates the duration of paternity leave is RA 8187, or the Paternity Leave Act of 1997. Section 2 of the said law states that every married male employee in the private and public sectors shall be entitled to a paternity leave of 7 days
with full pay for the first 4 deliveries of the legitimate spouse with whom he is cohabiting. Meanwhile, Article 131 of the Labor Code affords a total of 6 weeks of maternity leave for women. Such period was further amended to 105 days by way of RA 11210 or the 105-day expanded maternity leave law. Clearly, there is a huge discrepancy between the duration of maternity and paternity leaves. Mothers are afforded 105 paid days, while fathers are given merely 7 paid days. In order to compel employers to equalize the discrepancy between the two leaves, I wish to use Article 2 of the ILO Convention Number 100, or the Equal Remuneration Convention, which states that each member shall, by means appropriate to the methods in operation for determining rates of remuneration, promote and, insofar as is consistent with such methods, ensure the application to all workers of the principle of equal remuneration for men and women workers for work of equal value. Article 1 of the same convention defines remuneration as inclusive of the ordinary, basic, or minimum wage or salary, and any additional emoluments whatsoever payable directly or indirectly, whether in cash or in kind, by the employer to the worker and arising out of the worker's employment. This rule of international law is binding upon the Philippines because it is a signatory to the convention. This specific convention was ratified by the President on May 21, 1953, and concurred in by the Senate or the National Assembly then on October 28, 1953. Due to the year being 1953, it is important as it means that the Constitution at force at the time was the 1935 Constitution, the relevant portion being Article 7, Section 11, Paragraph 7. Thus, this rule of international law has been domesticated through the process of transformation, and hence it is applicable in the Philippine legal system. The gap that I would hope to fill through the convention is the 98-day difference between paid maternity leaves and paid paternity leaves. So, to reiterate, we can use this rule of international law to compel employers to grant 105 days of paid paternity leaves to male employees. Thank you, and I would now like to introduce the next speaker, which is Ms. La Chica.
Hi everyone, good afternoon. Similarly, with the previous speaker, I will be discussing the UN Convention on the Rights of the Child as basis to compel employers to provide a 105-day paternity leave benefit. Imagine a hospital room. The father of a newborn baby carries the child and places it in the hands of an exhausted mother who has just successfully performed a miracle by giving birth. Together, they promise to take on the world and its challenges hand in hand. Fast forward to 7 days later, and the father again leaves the baby, a bottle of milk, and a heavy bag of diapers in the hands of the same and still very exhausted mother to go to work. The Paternity Leave Act gives a standard 7-day paternity leave benefit to married fathers. There is also a separate benefit under the expanded maternity leave law, giving the mother the option to allot a maximum of 7 days from her 105 days of maternity leave to the father of the child, regardless of whether or not he is married to her. From such, you can see the clear disparity in the standard benefits granted to working fathers and mothers under our labor laws. This is where the UN Convention on the Rights of the Child come in. Under Article 18 of the Convention, states are mandated to ensure recognition of the principle that both parents have common responsibilities for the upbringing and development of the child, and to render appropriate assistance to parents in the performance of their child-rearing responsibilities. The Convention was created through one of the 3 processes accepted by the international community of states or by means of treaty making. The rule is also binding upon the Philippine state internationally, as the Philippines signed the instrument on January 26, 1990 and complied with the requirements laid down in Article 49 after the deposit of the instrument of ratification with the Secretary General of the United Nations on August 21 of the same year. The international law has also been domesticated via transformation following the concurrence of the Senate with the ratification of the President on July 26, 1990. Thus, this treaty, rendered valid and effective after Senate concurrence to the presidential ratification, enjoys the same status as a statutory law. More importantly, the cited domesticated rule does not conflict with our existing municipal laws, but rather fills in a gap to compel employers to provide a 105-day parental leave benefit already enjoyed by the working mothers. Under the convention, the theory is that the state shall provide similar, if not the same benefits and assistance to both parents to ensure the performance of their child-rearing responsibilities. While the convention does not expressly state the extension of paternity leaves to working fathers, we can apply the rules of interpretation under the VCLT. The term common responsibilities recognizes the role of both parents for the upbringing and development of the child during his or her childhood. The convention, giving importance to the role of both men and women in child rearing, does not distinguish in its use of the term parents. Extending the same benefits to the father of child would also be more in line with allowing parents to fit in their new roles and afford protection to the family of the child while not shifting the burden to the mothers to nurture the child alone. To recall, under Article 18, the state is mandated to render appropriate assistance, which necessarily includes parental leave benefits, to help in the performance of the said common responsibilities, not only to the mother, but likewise the father. In fact, the idea is not at all novel. There are other countries who are also signatories to the convention, which implement the same treatment of parental leave benefits to working mothers and fathers. A prime example is Spain, which increased the paternity leave benefit in 2019 until it reached 16 weeks in 2021, which is the same amount given to working mothers. Such treatment of leave benefits is more in line with the ideals of the UN Convention on the Rights of the Child, recognizing the equality of all persons, as well as highlighting the importance of family and all the members in shaping and building the personality of the child. Now we find ourselves back in that hospital room. By virtue of the convention, the new parents don't need to sacrifice to decide which of them will stay with their child, at least for the first 105 days. For this period, the family can enjoy a simpler time with each other, worrying less about money and work. Thank you very much. For the next topic on labor law, may I call on Ms. Lemoso?
Good afternoon, everyone. My topic for this presentation is the use of the Convention on the Rights of Persons with Disabilities to authorize a PWD employee to avail of sick leave for injuries arising from attempted suicide. This contemplates a situation where an employee with a mental health condition, a mental impairment, or one with a temporary loss of decision-making capacity, as defined under the Mental Health Act, suffers serious injuries from a suicide attempt and is compelled to work the next day or risk leave without pay. This is possible when an employer stipulates in a labor contract that the use of sick leaves shall not be allowed for the cause previously mentioned. Currently, Philippine laws allow for such stipulations under the principle of autonomy of contracts in the Civil Code. Moreover, Article 95 of the Labor Code, which only grants a mandatory service incentive leave of 5 days, provides that the grant of benefits in excess of that provided herein shall not be made a subject of arbitration or any court or administrative action. While there is a Philippine law in place which may address this problem, which is the Mental Health Act of 2017, it is too general to serve as a basis for relief when it comes to workplace policies, specifically allowances for sick leaves. Section 25 of the Act only provides that employers shall develop appropriate policies and programs on mental health issues, correct the stigma and discrimination associated with mental conditions, identify and provide support for individuals with mental health conditions to treatment and psychosocial support. On its own, Section 25 is vague, since it does not clearly define what would constitute appropriate and supportive programs and policies on mental health in the field of labor relations. Thus, we look to international law for a possible clarification. The Philippines is a state party to the Convention on the Rights of Persons with Disabilities, or the CRPD, which it signed and ratified and which took effect on May 3, 2008. Its formal source is an international agreement, and its material source is the text of the CRPD itself. In particular, Article 27H of the CRPD mandates the promotion of the employment of persons with disabilities in the private sector through appropriate policies and measures, which may include affirmative action programs, incentives, and other measures. The Philippines, as a state party, is bound to comply with its obligations under the CRPD in good faith, as the CRPD has already been transformed into the Philippine legal system as an executive agreement. It therefore has the force and effect of an executive regulation. Under the principle of lex specialis, Article 27H of the CRPD bolsters the purpose of the Mental Health Act and provides a more specific basis for relief through reasonable accommodation for PWDs as to workplace incentives. Following the CRPD's object and purpose and interpreted along with subsequent practice in line with the Vienna Convention on the Interpretation of Treaties, there is a resulting reinterpretation of Philippine legal rules. Pursuant to its treaty obligations under the CRPD, the Philippines passed the Mental Health Act and the DOLE Department Order No. 208, or the Guidelines for the Implementation of Mental Health Workplace Programs and Policies for the Private Sector. Paragraphs 4C.1a and 4C.4a and b of the order specifically require that work accommodations for PWDs include non-discrimination policies and practices as to their employment benefits and flexible leave arrangements, respectively. Moreover, failure to comply with these rules merits a penalty under RA 11058 or the Occupational Safety and Health Guidelines. Thus, construed together with Article 27H of the CRPD, these rules can provide a clearer basis to authorize a person with disability to avail of sick leave in case of injury arising from attempted suicide. Thank you. May I call on the next person, Mr. Martinez.
So, good afternoon to everyone. At this point, I will discuss how international labor law via ILO Convention number 141 can be used to help rural workers' organizations in being able to receive foreign assistance by authorizing the same without prior permission from either the DOLE Secretary or the DAR Secretary. Now consider the following scenario. Suppose there's a business named Marino Furniture Company located in Masbate, which has employed about 200 local residents as wage workers based from the same rural area. These workers manufacture furniture from local materials and send it to the company for export. As such, the said residents have organized a labor organization known as the MFC Workers Association, which acts as the bargaining agent for the workers. While they are able to function as a labor organization, their funding to be able to enhance their activities has been inconsistent on a regular basis since they couldn't fully enforce having each member pay contributions. However, one of the company's top foreign clients in Mr. Alex Jackson, an American business owner, intended to use his private charity to donate $20,000 to the said labor organization. He sought to ask for permission to have the donation granted by the DOLE Secretary, but his request was denied, with the DOLE Secretary citing suspicion regarding the source of the said donation. Had this donation been granted, it would have been beneficial to help the said labor organization. But without it, the said labor organization is currently struggling to function effectively. Now then, we see the problem here. Foreign assistance to rural workers' organizations is strictly prohibited unless permitted by the DOLE Secretary or the DAR Secretary in certain cases, mainly because the Philippine rules restrict it, as provided in both Articles 285 and 286 of the Labor Code. Simply put, in Article 285, no foreign individuals or organizations can provide assistance to any labor organizations or group of workers in relation to any trade union activities without prior permission by the Secretary of Labor. Article 286 also emphasizes the prohibition of giving foreign assistance to rural workers organizations unless permitted either by the Secretary of Labor or, in some cases, the Secretary of Agrarian Reform. However, international labor conventions recognize the rights of rural workers organizations, mainly through the Rural Workers Organizations Convention, which was adopted at Geneva on June 23, 1975. And one of the key rules that they provided in the said convention is in Article 5, in which it requires ratifying member states to eliminate obstacles to the establishment and growth of rural workers organizations, including ensuring national laws and regulations do not inhibit the same. Given this, one can ask then for a legal remedy through a special civil action to authorize foreign assistance to such rural workers organizations. But the next question is, why should the Philippines bind itself to this convention? The answer is mainly because we are a ratifying state to it, with the President of the Philippines ratifying the convention on May 1, 1979, and an instrument of ratification being deposited on June 18, 1979. As such, the said deposit of instrument of ratification is sufficient to show that the Philippines consents to be bound by the said international agreement. And by June 18, 1980, it was entered into force by the Philippines. At this point, the said international agreement has then been domesticated through transformation by ratification, being on the same level as that of statutes. In this sense, by applying the domesticated international law in the Philippines, it can then be said that there exists a conflict between both the domesticated international law and that of the relevant Philippine rule at hand. And in order to establish how the domesticated international law becomes superior over the said provision of the Labor Code, sequential analysis provides us the doctrine of lex posterior derogat priori, which essentially means that the latter law is superior to that of the earlier law. In this case, the effectivity of the said international law being enforced by 1980 in comparison to that of the Labor Code, which was enacted on May 1, 1974, meant that the said domesticated international law stands superior to the Labor Code, which means that the said provision seeking for ratifying member states to eliminate obstacles in national laws from inhibiting rural workers' organizations should stand over the general rule of prohibiting foreign assistance to labor organizations. Therefore, rural workers' organizations should not be hampered by the national laws in its right to be able to receive foreign assistance whenever the opportunity arises. And as such, they should be authorized to receive the same without prior authority permission from that of either the DOLE Secretary or the DAR Secretary in certain cases. That will be all for my part in this discussion. And as such, thank you, and I would like to introduce the next speaker, Mr. Vadelas.
Good afternoon. I am Joseph Edward Rodelas, and I am dealing with the legal problem that employers are contacting employees outside work hours. So if you will look around and ask some Filipino employees if they have been sent a work-related email or text beyond their work hours, most probably the answer would be yes. And it is kind of unfortunate that this has been the situation for so long. Technology has blurred the line between productive work and personal space, and a lot of people experience this kind of communication beyond work hours that has been affecting employees physically and mentally. Employers tend to weaken their employees' work-life balance and job performance when they create expectations that work emails should be monitored and responded to during non-work hours. In fact, there are studies showing that expecting employees to answer emails after work hours is detrimental to them. In a way, these modern workplace technologies may be hurting the very employees that those technologies were designed to help. The legal relief that I am seeking is to prohibit employers from contacting employees outside work hours. The relevant Philippine rule here would be Article 83 of Presidential Decree 442 or the Labor Code, which provides that the normal hours of work of any employee shall not exceed 8 hours a day. Further, Article 84 provides that what shall be included as hours work. Work hours exceeding 8 hours can still be done, provided that there is an arrangement between the employer and employee for work beyond 8 hours and that the corresponding overtime pay is given. These provisions are lacking as there is nothing in them that prohibits employers from contacting employees outside work hours. So under Article 24 of the Universal Declaration on Human Rights, or UDHR, everyone has the right to rest and leisure, including reasonable limitations of working hours and periodic holidays with pay. The principles embodied in this provision are part of the norms, principles, and practices that influence the behavior of states. As customary law, it is created through the general and consistent practice of states, followed by them from a legal sense of obligation. Further, as provided by Waldock in his general course on public international law, the UDHR possesses legal authority as an authentic interpretation of the provisions of the UN Charter concerning human rights. Since the adoption of the UDHR, its provisions have been incorporated in a number of municipal laws. So the UDHR is domesticated into the Philippine legal system through the incorporation clause of the 1987 Constitution, and it has a status of a statutory rule. This domesticated Philippine international law rule has the effect of filling a gap in the Philippine legal rules. Article 24 of the UDHR speaks about the right to rest and leisure. This right is an economic, social, and cultural right to adequate time away from work and other societal responsibilities. Since this includes a reasonable limitations of working hours, the work-related communications outside work hours should not be allowed, as this would run counter to the provision that working hours should be reasonably limited. In relation to the relief I am seeking, there is this right to disconnect, which is a human right regarding the ability of people to disconnect from work and not to engage in work-related electronic communications, such as email and text messages during non-work hours. Applying this in my case, not being contacted by your employers ensures that your right to disconnect is respected. And in effect, the right to rest and leisure is also respected as it encompasses the former. Thus, Article 24 of the UDHR as a domesticated pill rule can be applied to prohibit employers from contacting their employees outside work hours. In prohibiting them, employees should not be penalized for not routinely performing work outside normal hours and refusing to attend to work matters outside their normal working hours. That ends my presentation. I would like to call on the next speaker, Ms. Santos.
Good day, everyone. I am Clarissa Santos. In 2021, the Philippine Statistics Authority had recorded a total of around 1 million micro, small, medium enterprises, or MSMEs, operating in the country. 90% of these are micro business enterprises. The MSMEs accounted for around 65% of the country's total employment. Micro businesses alone had the biggest share with 32%, and this translated to around 1.7 million jobs generated for Filipinos by micro businesses alone. However, this also means that roughly around 1.7 million Filipino workers may not be receiving the prescribed minimum wage because under the BAMBI Act of 2002, Barangay Micro Business Enterprises, or BAMBIs, including agricultural ones, are exempted from the minimum wage requirement. A BAMBI is defined as any business enterprise engaged in the production, processing, manufacturing of a product, including agro-processing, as well as trading and services, with total assets of not more than 3 million pesos. The aim of this case study is to compel BAMBIs that employ agricultural workers to pay the prescribed minimum wage. The international law solution is ILO Convention number 99. Under Article 1 of the said convention, each state that ratifies the convention must create and maintain a machinery whereby minimum wages can be fixed for workers employed in agricultural undertakings and related occupations. Now, how is the Philippines bound under this rule? The President had ratified the ILO Convention in 1953, and in the same year, it was concurred in by the Senate. The convention entered into force in the Philippines in 1954. Due to its legislative and executive imprimatur, the convention is regarded as being on the same level as a statute. The ILO Convention number 99 conflicts with the Bambi Act of 2002. On one hand, under the ILO Convention number 99, workers employed in agricultural undertakings and related occupations are entitled to minimum wages. However, under the Bambi Act of 2002, which include businesses involved in agriculture-related industries, such as agro-processing, are exempted from providing the minimum wage rates to their employees. To resolve this conflict, sequential analysis shall be applied. Step 1. Lex superior cannot apply since ILO Convention number 99 is regarded as being on the same level as Bambi Act of 2002. We move on to step 2. Lex specialis would be applicable, and under this principle, a special provision of law prevails over a general one. The Bambi Act of 2002 applies to a broader type of business or industry. Hence, it affects a more general classification of workers. It contemplates both agricultural and non-agricultural work. Furthermore, Bambi Act of 2002 contemplates not just the exemption of Bambis from minimum wage, but also other benefits and incentives given to such business enterprises. Whereas under ILO Convention number 99, it is specifically agricultural workers who are entitled to minimum wages. Moreover, the ILO Convention is a specific law that deals with minimum wages. Therefore, as a special provision of law, ILO Convention number 99 must prevail over the Bambi Act of 2002 in order to promote the social and economic conditions that would turn agriculture into a remunerative occupation and to lay down the foundations for higher standards of living for all agricultural workers. Bambis that employ agricultural workers must pay the prescribed minimum wage pursuant to ILO Convention number 99. Thank you for listening. The next speaker is Ms. Sikihor.
Good afternoon. The Philippine problem that I outlined in this case study is how child influencers are actually not covered by current labor laws. The amazing thing about social media is that through social media, anything and everything is within reach, and this includes celebrity status. Gone are the days where you had to rely on looking good in public and having an ABS-CBN caster or talent scout find you in the streets and be like, hey, you're good looking. Do you want to be a model? Now it's just as simple as owning a smartphone and being in the right place in the algorithm and maybe having a funny or witty caption and a brand recognizing you. And then what do you know? You're an influencer. The other thing that's really amazing about social media is that the bar for entry is so low that literally anyone can become an influencer. You could be 60, you could be 16, you could also be like 6 months old. That's how vast the influencer industry are. So let's look at now what happens when you are a child influencer, right? What are the labor law? What are the protections actually afforded to you if you are a child influencer? Meaning to say that you take pictures of yourself or your parents take pictures of you, and you eventually generate sponsored ads or sponsored ads in the form of looking like a relatable, everyday child. The thing is, while social media has changed the field of marketing, media, and communications, local law has subsequently become insufficient to properly protect children engaged in that industry. If you look at the Republic Act 9321, which talks about working children in the entertainment industry, because that's really for certain age groups, at least for those who are 14 and below, the only types of media that they can actually participate in are ones where it's like public information or things like shows which, well, you need to hire real children for it to be believable. The way that the state is able to protect children from instances of exploitation through overwork or simply using them as cash cows is by limiting the number of hours of work and subsequently ensuring that the revenue that they generate or their income is properly handled by their parents and that they have to set it aside in a trust fund. But what it does fail to contemplate are the arrangements that influencer marketing has now given us, in that if you're at home, you don't really have to punch in the clock, right? You just have to take pictures, maybe put out maybe edit it for a few hours, definitely less than 4 hours for sure. And that content will continue to generate revenue for around the clock for every click that it gets. So what is protecting then the child from being exploited in that they're not able to access any of that money? Or how does the state actually ensure that within the confines of the home, we know that the child isn't being coerced into posing or to even being taken away from their peer group or their friends just so that they can produce all this content for their parents? That's why I would posit that it would be better to then prohibit parents from monetizing social media content featuring children 14 and below. Because if you look at it, the way that traditional marketing has been done has always been in a way where we could calculate it on the basis of hours. But absent the long hours of work that we put in, that these child influencers put in, the one thing that we control is the ability for the content that their parents put out for them to be monetized. The legal relief I'm seeking, therefore, cannot be seen in local laws. Instead, we have to look to fill this gap through the Convention on the Rights of the Child. The UN Convention on the Rights of the Child has enjoyed the status of being on the same level as statute, as it has already been domesticated through its signing and ratification in 1990, and its subsequent Senate concurrence in 1992. Under the convention, states parties recognize the right of the child to be protected from economic exploitation and from performing any work that is likely to be hazardous or to interfere with the child's education, or to be harmful to the child's health or physical, mental, spiritual, moral, or social development. Clearly, while RA 9321 has been able to protect the traditional arrangements of how influencers or how children are able to participate in marketing media, there has to be a way, the convention has given us a way to enforce this prohibition to make sure that we are able to catch up with the times. Because in as much as social media is constantly evolving and sometimes legislation may take its time, we still must make our best effort to catch up with it. Thank you. May I now introduce the next speaker, Mr. Suay Baguio.
Good afternoon to everyone. My name is Bosbal Bagyo, and I will be presenting my case study revolving around the problem of unmarried male employees not being able to avail of paternity leave. RA 8187, or the Paternity Leave Act, requires two concurring things in order for a male employee to apply for the leave. First, Article 2 informs us that they must be married to the mother of their child. And second, the title of the act states that they must be cohabiting with the same. This severely limits the applicability of paternity leave to one specific situation, when the dynamic and the arrangements between partners could be as varied as complicated as they come. Moreover, Article 3 of the Paternity Leave Act raises some concern, where it qualifies that the leave of the male employee is one in order to give aid and support to the mother in the care for their child. This perpetuates harmful and archaic stereotypes that it is the mother who has the primary duty to take care of the newborn child, that the father is not expected, nor are they seen to be able to care for their child by themselves. I seek to address this problem through the solution of authorizing unmarried employees to paternity leave. In discussing my solution, I now enter the 7-step analysis. First, I have identified the Convention of the Elimination of All Forms of Discrimination Against Women, particularly Article 16, which states that a state shall take all appropriate measures in order to eliminate all forms of discrimination against women, and that it shall ensure the same rights and obligations between the man and the woman when it comes to married and family life, and that the interest of the child is paramount. In identifying this provision, I do not preclude the applicability of other provisions, such as Article 5 of the Convention, stating that a state shall battle the cultural and culturally accepted norms that are based in gender stereotypes, nor do I deny its relation with similar worded provisions, such as in the Convention of the Rights of the Child. Second, the formal source of the convention is the treaty-making process, while the material source is the text of the treaty itself. The contents of the convention of the CEDAW is one that the state has obliged itself to follow, which leads us to the third step. This Philippine state is a party to the CEDAW. On July 15, 1980, we signed into the treaty, and on August 5, we ratified the same. We have since adhered to the contents of the provision of the convention, seeing as how in 2003 we ratified the optional protocol to the CEDAW, as well as passed numerous amendments and laws in line with our obligation the same, including but not limited to the Family Code, the Magna Carta for Women, and the Anti-Vowsy Act. Its domestication into our jurisdiction was one of transformation. And although under present day, Article 7, Section 21 governs and requires the concurrence of at least 2/3 of all members of the Senate, we must note that this came before the 1987 Constitution. And under Article 14, Section 16 of the 1973 Constitution, the President could enter into international treaties when national interest or welfare demanded such. Hence, it sits comfortably on the same hierarchy as that of a statute. The implication here, however, is that there is a conflict between the two. And in resolving this conflict, we apply the sequential analysis. Unfortunately, the first step is of no aid, given that they occupy the same level in our hierarchy, which is why I submit that the second step shall break the impasse, where Lex Specialis states that where a domesticated international rule employs more specific terminology and terminology in its provisions, then it shall govern over the more general statutory rule. Herein, the Paternity Leave Act merely uses the general terms of man, woman, and child, and does not truly acknowledge what relationship or what obligations it has between the three of them, while the CEDAW specifically uses the terms of parenthood. It specifically acknowledges the obligations between man, wife, and child, and so it must be the one to govern. To end my presentation, I leave with this note. Where we authorize the Paternity Leave Act for single males, it is in line with the idea that men must be better. But for men to be better, we cannot stop them from taking the first step. Thank you, and I now cede the floor to the next presenter, Mr. Vincent Uy.
Imagine, a fresh college graduate is applying for a sales and marketing position in a multinational company. He was asked to complete an online application and to accomplish a personality test, the result of which would be considered whether or not he is qualified for the said job position. To proceed with his application, he had no choice but to consent to such use of confidential information. Let's say that the applicant showed that he is an introvert, but the employer was more inclined to hire an extrovert because of the prejudice that the said job position would entail extroverts who are better presenters and sales pitchers than introverts. Hence, he was disqualified based on his personality type. It begs the question, was the applicant discriminated for being an introvert? My position is that personality types as basis for employment discriminately categorizes people into templated profiles. In using personality types, employers already give undue preference for certain personality types that they think would be fit for the job position, when in fact it is unreliable and not predictive of job performance. In other words, when an employer has a fixed personality criteria for a job position, they overlook qualified candidates. In fact, designers of these personality types, such as the MBTI, have already cautioned employers against their use in hiring job applicants. Why? Because the problem with using the results of personality tests, such as the personality type that is employed by MBTI, would disclose personal information that may be sensitive in relation to matters of employment and may be used to discriminate against the candidate for future employment. Hence, when an applicant is assessed based on personality type, it is akin to asking him to tick a box which is merely descriptive of him, much like asking someone of their gender, marital status, religious, or political affiliation. However, unlike gender, marital status, and the like, personality type is not listed or considered as sensitive information based on the Data Privacy Act of 2012. But under the international law, the ILO Convention number 111 on discrimination regarding employment and occupation, Article 1 provides that the term discrimination includes such other distinction, exclusion, or preference which has the effect of nullifying or impairing equality of opportunity or treatment in employment or occupation. This broad definition allows the inclusion of personality types as a distinction or preference that could impair equality of opportunity in employment and is therefore discriminatory. The ILO Convention number 111 is an international agreement which the Philippines is bound as a member state party, having been ratified by the President and the Senate and concurred by the Senate on May 16 and 19, 1960 respectively, with the instrument of ratification having been deposited on November 17, 1960, thereby giving it the force and effect of law. Such international agreement was transformed and has since been domesticated into Philippine law on the same level as statutes, as the same with Data Privacy Act. Hence, the ILO Convention fills a gap in the Data Privacy Act because Philippine laws are silent on the use of personality types in disqualifying an applicant. But this convention can be invoked to prohibit such use. As such, the relief sought may be achieved with the aid of ILO Convention 111. Again, while personality types can help in training, learning, and development, when an employee is already within the organization and voluntarily takes the test, it is discriminatory when used as an evaluation tool to disqualify a job applicant. Thank you. The next speaker is Mr. Antonio.
Good day, everyone. The family, as a basic social institution, is one that the law and the state seeks to protect. In fact, its importance is further highlighted by the fact that the preamble of the International Covenant on Civil and Political Rights, or the ICCPR, considers that the recognition of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world. In relation to this, one of the problems in the context of Philippine law is that women do not incur criminal liability under the Anti-Vowsy Act for violence committed against men. In other words, men are not entitled to the protection under the provisions of the said law. Section 2 of the law even declares that the state needs to protect the family and its members from violence and threats to their personal safety and security. However, its provisions only protect women and children. Specifically, Section 5 of RA 9262 enumerates the acts constituting the crime of violence against women and their children. Section 5I states that causing mental or emotional anguish, including the denial of financial support, constitutes the crime. However, Article 26 of the aforementioned ICCPR states that all persons are equal before the law and are entitled without any discrimination to the equal protection of the law. Moreover, discrimination on any ground, such as sex, is prohibited by this article. The ICCPR is an international agreement to which the Philippines is bound. The covenant was signed on December 19, 1966, and ratified by the Philippines on October 23, 1986, through former President Corazon Aquino. It is important to note that during this period, the revolutionary president had legislative powers, which was confirmed by Article 2, Section 1 of Presidential Proclamation Number 3, which stated that until a legislature is elected and convened under a new constitution, the president shall continue to exercise legislative power. Therefore, the ICCPR is a treaty and not merely an executive agreement. Proceeding from this, under the hierarchy of Philippine legal rules, the ICCPR is under the second tier, which makes it in the same level as a statute, such as RA 9262. It is submitted that the ICCPR should be applied to reinterpret the provisions of RA 9262 so that men may also enjoy the protection of its provisions. To further illustrate the issue, let's say Juan and Maria are married and blessed with 5 minor children. Maria, however, left the family and does not give any financial support to her children or to her husband. Juan was thus left on his own to care for their children, providing their needs and paying for their education. Because of this, Juan has been suffering from mental or emotional anguish from Maria's act of refusing to give financial support to Juan, despite him having to solely raise and support their 5 children. In this hypothetical situation, if the letter of RA 9262 would be strictly followed, then Juan would not have any recourse under the said law. However, if the facts were reversed and Maria, the wife, was the one who was left to support the kids, then she would have recourse under Section 5I of RA 9262. The situation shows the unreasonable and unjust effect if men would be excluded from the protection of the provisions of RA 9262. Such a situation would be contrary to the international obligation of the Philippines under Article 26 of the ICCPR to prohibit any discrimination and guarantee all persons equal and effective protection against discrimination on any ground, such as sex. Therefore, it is submitted that on the basis of Article 26 of the ICCPR, courts should be authorized to criminally prosecute women for violations of Section 5I of the Anti-Vowsy Act committed against men. Thank you very much for listening. Now I would like to introduce the next speaker, Ms. Therese Bocobo.
Good afternoon. Up until recently, the Philippines was renowned for having one of the lowest ages of consent in the world. In fact, just this time last year, as far as our law on statutory rape was concerned, a child as young as 12 years old was deemed capable of engaging in consensual sex with a full-grown adult. But just last March, with the passage of Republic Act number 11648 amending our revised penal code, the Philippines had finally raised the legal age of consent to 16 years old, pursuant to the state policy to strengthen our protections for our children. Now, as laudable, albeit long overdue as this sounds, it is my submission through this case study that we still have a lot of ground to cover. While the amended law raised the legal age of consent, it also opened a gap which allows an 18-year-old adult to commit statutory rape against a 15-year-old child and still escape criminal liability in certain cases. See, this new law carved out an exemption in our revised penal code which precludes criminal liability from attaching to a person committing statutory rape under certain requisites. First, that the age difference between the offender and his victim is not more than 3 years. Second, that the sexual act is somehow proven to be consensual, non-abusive, and non-exploitative. And third, that the victim is not under 13 years old. As you can see, despite these safeguards, there is no clear express language in our law that this exemption should not apply to an 18-year-old adult committing statutory rape against a 15-year-old child, should the adult offender be allowed, and does in fact, establish these requisites. But there's hope. The relief I seek in my study is to authorize courts to hold adults having carnal knowledge of children aged 15 years old criminally liable for statutory rape when all elements of this crime are present. This is because we can read our statutory rape law in conjunction with the United Nations Convention on the Rights of the Child, or the CRC, to fill the gap, such that this exemption finds no application in cases of statutory rape against a 15-year-old victim, notwithstanding the presence of all these requisites. The Philippines became a signatory to this convention on January 26 of 1990. This was ratified by the President in August of the same year. And on July 26 of 1990, this convention had been officially domesticated in the Philippines through transformation when the Senate concurred in the President's ratification. The treaty then occupies the same level as a statute and is binding as such. Article 34 of this treaty expressly mandates that states parties shall take all appropriate national, bilateral, and multilateral measures to prevent the inducement or coercion of the child to engage in any unlawful sexual activity. Statutory rape, as defined in our revised penal code, remains an unlawful sexual activity. It is based on the premise that children cannot legally consent to sexual intercourse until they reach 16 years old. Until then, their tender age means they are yet incapable of making an intelligent decision on the matter. They are not free to make that choice for themselves. And in cases of statutory rape, who else takes it upon themselves to make that choice for the child but the adult offender, by no means other than through inducement or coercion? That is what the state is treaty bound to prevent. Though our law does not expressly state that the exemption shall not apply to 18-year-old offenders raping a 15-year-old child, reading our amended law on statutory rape together with the CRC, we arrive at the inevitable basis to authorize judges to hold 18-year-old offenders criminally liable for the statutory rape of victims of the tender age of 15 years old. Thank you. And for our final presenter for this afternoon, please welcome Mr. Quijano.
Hello. Okay. So good afternoon. I am Miguel Quijano, the final presenter of the J.D. students. So my Philippine law problem is the unavailability of emergency contraceptives to women in the Philippines. So this case study seeks to reverse the ban on emergency contraceptives and its categorization with abortive patients. So as the country starts to resume face-to-face operations amid declining COVID-19 cases, health experts fear unwanted pregnancies will surge and return now that more interactions are allowed as we are close to getting back to normal. So, COVID lockdowns actually caused the rate of unwanted pregnancies in the country to decline, albeit temporarily. So this leads the conversation on available contraception to women in the Philippines, specifically emergency contraception. So in the 21 years since the FDA declared emergency contraceptives as an abortifacient in 2001, studies in the scientific community rejected any links of the easy pills to abortion. So in the same year, the Philippines approved the easy pill Posinor for importation and sale in the country, but the Bureau of Food and Drugs later canceled its approval. The reason stated was its abortifacient effect, meaning it causes abortion. So medical researchers worldwide have concluded by consensus that EC, or emergency contraception, is contraception and not abortion. There is no significant debate on the question whether or not this is true in the field of OB/GYN science. So even the World Health Organization's fact sheet on the topic states that EC pills prevent pregnancy by preventing or delaying ovulation, and they do not induce an abortion. So the relevant Philippine rules and laws would first be the two articles under the revised Penal Code of the Philippines, specifically Article 258 and 259, or abortion practiced by the woman herself or by parents, or abortion practiced by a physician or midwife and dispensing of abortives. Next would be the 1987 Constitution, Article 2, Section 12, wherein it states that the state shall equally protect the life of the mother and the life of the unborn child from conception. And finally, the RH Bill, or RA 10354, states that officers shall not purchase or acquire by any means emergency contraceptive pills, post-coital pills, abortifacients that will be used for such purpose, and the other forms or equivalent. So the public international rule relevant to this case study is the CEDAW, which provides that states parties take all appropriate measures to modify or abolish existing laws and practices which constitute discrimination against women. Article 16, paragraph E states that state parties shall afford and in particular shall ensure the same rights to decide freely and responsibly on the number and spacing of their children, and to have access to the information, education, and means to enable them to exercise these rights. So the formal source of the rule is the treaty-making process, while the material source is the actual text of the CEDAW. So the CEDAW became part of the domestic law by transformation under the Constitution as the agreement was ratified during the 1973 Constitution, and is a treaty under Philippine law as it was ratified pursuant to the Prime Minister's power under Section 15 of the amended 1973 Constitution. So in the hierarchy of rules in the Philippine legal system, the domesticated PIL rule is on the second tier because it is considered on the same level as a statute. So basically, the CEDAW can be used to clarify the inconsistency in the RH Bill, which states that officers shall not acquire or purchase emergency contraceptive pills or abortifacients. So this section basically classifies emergency contraceptive pills in the same category as abortifacients, while in the IRR of the bill, it defines the former as methods of contraception that can be used to prevent pregnancy in the first few days after intercourse intended for emergency use, and that these are effective only in the first few days following intercourse, before the ovum is released, and before the sperm fertilizes the ovum. Basically, the conclusion is clear that the RH law mandates the protection of life should be afforded from the moment of fertilization, and that it prohibits any device that prevents a fertilized ovum that be implanted in the mother's womb as an abortifacient. So coupled with this would be the discussion in Imbong versus Ochoa that the court had, stating that the legislative intent of the framers of the Constitution states that contraceptives that actually prevent the union of the male sperm and the female ovum, and those that take action before conception or prior to fertilization, should actually be deemed non-abortive and thus constitutionally permissible. So the the World Health Organization states that the emergency contraceptive pills, once again, prevents pregnancy by delaying ovulation, and it does not induce abortion. So in other words, emergency contraception cannot interrupt an established pregnancy or harm a developing embryo. So this further clarifies that emergency contraceptives are in fact not abortifacients in the sense that they stop the womb from releasing an egg, thus conception cannot occur. So thus, with the aid of the public international law, I would like to compel the public health facilities to dispense and guarantee supervised access to emergency contraceptives. So under the CEDAW, it is discriminatory for a state party to refuse to provide reproductive health services for women because these concern distinctive biological features and risks that only women that affect only women. So equality requires a state party to attend to these risks and to avoid disproportionate effects it will have on their health and opportunities, or in other words, since only women can get pregnant, they should have the right to choose. So the Philippines, a state party to CEDAW, is mandated to maintain equality by ensuring women's access to contraceptives that are constitutionally allowed under the law. So, in light of the provisions of the CEDAW, along with the plain reading of the Constitution, on the protection of life from conception, as well as the discussion of the court in Imbong versus Ochoa, and in line with the RH bill, it is necessary for a reinterpretation of emergency contraceptives as not to be classified as an abortifacient in all cases. Thus concludes the presentation of all JD students for today. To reiterate what Ms. Rodriguez had stated at the start of our endeavor, the case studies prepared by all of the students here today would not have been of the quality that they are if not for the guidance provided by our professor, Attorney Andre Palacios. So as we end our batch of presentations today, let us give him a round of applause, as well as to one another for reaching the culminating point of an entire SEM's worth of effort. So again, thank you for listening.
So we are near, but not yet at the end of our fourth session. We'll have a few questions. Okay, so first, can you move back to Binky's? Ayan. Yan. Yan ba yun? Okay, Binky. Sige. So what you want to do is you want to interpret the Anti-Vowsy Act in order to authorize criminal prosecution, meaning to expand its interpretation to cover acts that at the moment are not criminal, right? So how can we interpret Vowsy to to be unfavorable to the accused when in fact under criminal law principle we're supposed to interpret the criminal provision of the Anti-Vowsy Act in favor of the accused?
Sir, it is submitted that such an interpretation, rule of interpretation, cannot trump an international obligation of the Philippines under the ICCPR. So, as shown earlier, the ICCPR is a treaty, and in fact, it is in the same level as a statute. So, on that premise, it should not be overcome by a rule of interpretation, sir.
Okay, thank you. So a substantive rule cannot be overridden by a StatCon principle. Okay, thank you. Sige, Vito. Okay. So what you want is you want to prohibit employers from disqualifying based on personality, right? So you want to limit the discretion of the employer in selecting an employee, right?
Yes, sir.
Now, I was thinking, don't employers have full discretion to decide who they want to hire unless the discretion is limited by, by law, like a prohibition on discrimination on the ground of race, age, sex? But there seems to be no limitation under Philippine law or even under the ILO Convention on the discretion of the employer to hire on the basis of personality. So why do we interpret this international rule to limit the employer's discretion?
Yes, sir. Yes, sir. I would agree that it seems that there is full prerogative or management prerogative on the part of the employer when they hire or select for job applicants. And the problem with this is that because there is no express prohibition, they think that they do not commit any discriminatory act. And by interpreting the ILO Convention number 111, the beauty of this convention is that it anticipated, even though it was written in 1960, it anticipated that discrimination would include not only these distinctions or exclusions that were already provided in the ILO and in the Data Privacy Act, such as gender, marital status, and the like. Because in the ILO, it provided a catch-all phrase, which shows that they anticipated that even in the succeeding years, there would come a time that there might be other new developments. And as mentioned, one of those developments is the personality types in psychology, which would show that personality types may be considered as discriminatory because they create certain distinctions or exclusions or preference. And in using the ILO to fill the gap in our Data Privacy Act, it broadens what our perspective on what we would constitute as discriminatory. Yes, sir. Thank you, sir.
It's a catch-all provision,
Yes,
right, that
sir.
you're using. Okay, thank you. Bob? So, for Bob, you are invoking the Convention on Elimination of All Forms of Discrimination Against Women. So this international agreement has the object and purpose of benefiting women, protecting women. However, you're using this pro-women international rule to expand male benefits, right? How is it possible? How can this pro-women rule result in more male benefits?
Sir, I humbly submit that we may remain with Section 1, Article 31 of the VCLT, which states that the terms of the provisions are interpreted in good faith and according to their ordinary meaning in light of the object and context of the convention. Where the context and object of the protection here is that of women, we can understand that granting these rights to male employees and men in general would ultimately benefit those women, especially those who are in common law marriages or are in specific disenfranchised situations, since they're in the only recourse they have to have their partners aid them or have their partners take care of their child is through the Expanded Maternity Leave Act, which takes leave days off their own. So by granting this, they are still able to enjoy those added leave days and have the benefit of their partner also taking care of their children.
Okay, so may taga-luto, tsaka taga-hugas, tsaka laba, no? Okay, thank you. Mark? Is there Mark? Ano ba to? Mark? So for Mark, so you're pointing to the ILO Convention, no, pertaining to Rural Workers Organization. I was looking at the provisions. It does not seem to expressly authorize foreign assistance to rural workers' unions. Okay? So how can we interpret this ILO Convention to allow something that's restricted under Philippine law?
All right. So the way the Article 5 can be interpreted is that it acts more as a catch-all provision that basically allows such activities that is being restricted by national laws, but in turn are very beneficial for rural workers organizations to be authorized as such. So let's look at the first paragraph, and we can see there that there are two particular policies that are being put into place. One being the view to eliminate obstacles to the establishment of rural workers organizations and to eliminate legislative and administrative discrimination against rural workers organizations. Further supplement that with the second paragraph, there's each member shall ensure that national laws or regulations do not inhibit the establishment and growth of rural workers organizations. So given what has been provided in those statements, it becomes, like I've said before, it becomes a catch-all provision that ensures that member states who have ratified the ILO Convention number 141 shall ensure that their laws do not essentially inhibit the growth and development of such rural workers organizations. And considering the scenario that I have mentioned beforehand, the prohibition of foreign assistance to rural workers organizations without prior permission would be detrimental to their growth in the process. And as such, this particular provision can then be used to establish that it is to the best interest of the ratifying member states to authorize the said foreign assistance to such rural workers organizations.
Okay, thank you. For Ali. Okay, so Ali, you're using Article 18(1) and 2 of the Convention on the Rights of the Child, CRC. So if you look at the provisions, it refers to the common responsibilities of parents, right? But then you're using that provision on common responsibilities to obtain equality in the leave benefits, right? So if we look at the provision, it talks about common responsibilities but does not require equality, right? So what's your comment on that? And second, assuming that the CRC requires equality, it seems that CRC does not expressly require that fathers be given the 105-day leave. If it does require equality, can we interpret CRC to achieve equality by reducing the length of maternity leave to that of the paternity leave?
Okay, sir. So for the first question, as I mentioned earlier, we apply the rules of interpretation under the VCLT, particularly Article 31, which notes that the terms of the treaty must be interpreted in accordance with the ordinary meaning and in light of the treaty's objects and purpose. While the article does not provide for equal responsibilities, an underlying purpose behind the CRC, as reflected in its preamble, is the equality of all persons, not only the child, without distinction of any kind, such as gender or any status. Thus, I interpreted that to mean that it necessarily follows from that the parents should also have similar, if not the same, rights and corresponding responsibilities as well. For the second question, sir, the reverse cannot be upheld, as the assistance, as shown in Article 18, number 2, to be rendered by the state must necessarily be appropriate. Under the both laws, sir, under the Paternity Leave Act and Expanded Maternity Leave Law, the common goal is to allow the parents to assume parental roles. Thus, the 105 days provided under the Expanded Maternity Leave Act would be more appropriate period for the parents to assume parental roles. Additionally, sir, it would also be counterintuitive to the goal of the convention if we use the said provision to lessen the assistance afforded to the parents of the child, which would not protect the child and his family, sir.
Okay, thank you.
Thank you, sir.
For Angel, so we have 6 more minutes. Angel, let's look at your facts. If I recall correctly, your facts pertain to a resident trainee physician, right?
Yes,
or
sir.
group of them, right? And I think they're covered by item 2. They have a training program, correct?
Yes, sir. So that would exclude them from the employee
Which means they're not
relationship.
employees.
Yes, sir.
Okay? So if they're not employees, how would they be covered by the ILO convention, which I think applies only to employees? Not
Yes,
sure.
sir. So my approach for this Philippine problem was, although it is something that affects the resident trainee physicians, it would also affect the employees around them, so the health workers. Like in my hypothetical earlier, when the resident was instructed to cauterize the part of the patient, instead of the part of the patient, the resident ended up cauterizing or ended up burning the consultant who instructed him to do that and a few other nurses. So that created an occupational and safety hazard. So it's for the protection of the ones who are covered by the employee-employee relationship.
Okay, thank you. So they're benefiting indirectly.
Yes, sir.
By preventing the trainees from having to work 24 hours. Okay, thank you. Jessica. Okay, CRPD. So CRPD, if we read Article 27, it requires states, parties to CRPD to ensure reasonable accommodation. It does not specifically require employers to give PWDs 2 days of medical leave, right? So how can we interpret your Article 27 1
Aye, sir.
I ba yan?
Yes,
Hindi ba?
sir.
So letter yan,
Yes,
hindi yan
sir.
Romanet 1. Okay.
Yes, sir.
To require employers to provide 2 days of medical leave.
Okay, thank you for that question, sir. So here, according to Vienna Convention on the Laws of Treaties, Article 31.1, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context in the light of its object and purpose. In this case, applying the said rule on the text of the CRPD, reasonable accommodation must include the means and arrangements that will allow PWD employees to perform the essential functions of their job, with the assurance that they will also be able to prioritize their health without any fear of losing any part of their income. More so, reading Article 27H in relation to Article 27I of the CRPD, it mandates the promotion of the employment of PWDs in the private sector through appropriate policies and measures, including the affirmative action program, incentives, or other measures. And in this case, the requirement to give the PWD at least 2 days of medical leave will fall under the object and purpose of the CRPD in promoting and protecting the rights and the right of PWD employees in their workplace, sir.
Okay, thank you. I think we have time for one more presenter. I mean to ask question of one more presenter. So Bella. VCRT, no? So Vienna Convention on Road Traffic. If you look at Article 7.4, it requires drivers to not cause inconvenience to other road users, no? to road users. So how can we now interpret VCRT to obtain the relief you seek, to prohibit the purchase of sirens?
Okay, sir. So the VCLT provides that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. In line with this, Article 3 of the Vienna Convention of the VCRT states that contracting parties shall take appropriate measures to ensure that the rules of the road in force in their territories conform to the convention. So as applied, the VCRT imposes the obligation on road users not to endanger or obstruct traffic, and on drivers that their vehicles do not cause any inconvenience. So the sirens would fall under what Section 7 of the VCRT explicitly disapproves of, which is why it should be prohibited, sir.
Okay. Thank you very much.
Thank you, sir.
So we come to the end of session 4. I know you feel bad that we will have no more presentations. I wish to thank you for your hard work. I know that you spent many hours working on your case study. I hope that you'll be able to apply these principles, the 7-step analysis, when eventually you become lawyers. At the very least, I hope I have demystified international law in your eyes. You know, international law, these are not ordinary rules. They're not alien rules that you can't apply, okay? So don't afraid to invoke them, interpret them, manipulate them. And so I wish you well. We are not yet over with the semester. We still have to go back to our substantive rules of public international law. But I think we have already accomplished what I believe is the main purpose, main aim of the course, and that is for you to have a skill to have the skill required to apply international law in a Philippine case. As to what rules to apply, you can always search them. You know, it's like securities law or data privacy or competition. You don't really study them in class, but you'll know where to find them, right? And you'll know how to apply them. So I think for me, the technique, the skill is more important than the substantive rules. So, but the STEM's not over yet. We still have our topics to discuss. Some topics we did not do, right? I said asynchronous, so we'll catch up on those. And then also our provisions for memorization. That one we have to do. And I'm thinking of doing it synchronously. I'm gonna invite someone to, do face-to-face with you. I probably won't be able to do it with each of you, but I may be able to get someone to do it, no? Or a group of them. Why do we need to memorize? Because I think it's important. I've tried to identify the essential provisions, which will be your, if you don't have anything to say in your bar exam, you can fall back on some provisions. So I think those are the most important provisions. If you memorize them, I think you cover 90% of the risk, which is a good bet. Okay? So it's a good investment of your time. And believe me, if it comes out in the bar exam, you'll be grateful. Okay? So let's memorize. And we will do the memorization exercise. Okay? So again, thank you very much. And congratulations for your excellent presentations. Thank you. In closing, I wish to thank our event partners, the Philippine Judicial Academy, the Legal Education Board, the Integrated Bar of the Philippines, the Philippine Association of Law Schools, the Philippine Society of International Law, and also our support team here this evening. Our Beadles, of course, our Beadles, no? So si Antoy, si Eman, si Jet, and of course Chris from the LL.M. So kung nagpupuyat kayo, mas nagpupuyat sila. No? And also I'd like to thank the communications group for their support this afternoon, the video streaming, live streaming and video team. No? So who's here? Si Felix, si Roy, and Leo. Okay, and also meron tayong audio team, no, from UP Diliman. So thank you. Sino pa? Sino pa? Audio? Andun ang audio? Ayun. Okay. Also yung LEAP na nagbigay sa atin ng pagkain. Okay? Thank you and all the best. Congratulations.